Hello and good evening, everybody. Thank you so much for joining. Well, you can lay down there. Good girl. Sorry. Puppers. I hope this finds you well. I apologize for us not doing a Saturday night. Well, baby. Oh, okay. I had something come up that was very important I had to do. Go lay down. And so we're doing it tonight. I'm thinking there's a chance. I'm sorry, I'm taking my tennis shoes off. I'm getting comfortable. I'm thinking there's a big chance that I'm probably going to move our Saturdays to Sundays. It's just too many conflicting things. And we'll see. We'll see. But, however, we've got a lot to talk about. Hello, out and about with Diane. Hello, Melissa Webb. Welcome. Sarah Boone. I can't get that woman off my mind. And so I thought what we would do is between the 18th and 19th, we had a lot of documents drop. And she had a hearing on the 19th. Christy, hey, hey. Hello, baby. Hey, Haley Mouse. Oh, thank you. I got to spend time with my sister today. She felt well enough to get out. So we had a girls' afternoon. Um, but I'm seriously thinking about changing my lives on Saturday to Sunday. There's just a lot of conflicts. And next week, I have powwow. I have powwow. Hey, ADHD jelly bean. So, yeah, Saturdays are getting harder and harder in the fall for me to come on live. So we'll see what happens. But I'm toying with switching it to Sunday. It seems to be a little calmer day for me. And I have assignments due Saturday by midnight. Usually a tournament Friday, but I might need that little extra time. I'm doing okay, but you never know. Hey, Campfire for Life 22, how are you? Oh my gosh, y'all, thanks for joining. Uh, yes, yes. For those of you who don't know, she's got stage 4 metastatic triple negative breast cancer that has gone all over her body. So it's rare that I get to. She kidnapped me. She called me this morning. I was eating breakfast. She goes, "Come on." I'm like, "I'm there." Anything that woman wants, she gets. So I am, if it's all right with you, I am going to start off by going through the filings as of 9/18, and I'm still yawning. I don't know why I've been yawning all day. And then I want to watch some of the motion hearing from the 19th. And then we have documents that were filed after or on the 19th. Okay, so I would like to do that. Are you all up for that? Because tonight I'm going to stop. We're going to talk about it's not just going to be a run through. Carly's? Well, I don't have that information. Can you get it to me? Yeah, Sundays are good. I don't I've been out of pocket. But yes, we will. Let's start off with Sarah Boone. Get me that information in Discord, DM me, and I'll be happy to do it. So we're going to share screen. I don't know which one this is, but we'll share screen and see. Let me do this and begin it. Yes, that's the one I want. Okay, let me get everything organized, ladies and gentlemen, and get this like this. I hate that I have that the way I do, but it's okay. It's the way it's going to be. Okay. So This is the Ninth Judicial Circuit in the Orange County, Florida Criminal Felony Division. Motion for return of property in the alternative motion for independent exam by defense. Hmm. I'm not going to read every word. We're going to just bullet point because we've got a lot of documents to go through and a video. Of course, comes now Sarah Boone through counsel James Owen. Yes, please, thumbs up, like, subscribe, become a member. The big thing is like and subscribe. The said defendant, Sarah Boone, is charged in the above styled number case in a one count information with second degree murder, which is punishable up to life. The above numbered case, October 2nd of 2024, was set for jury selection. Ms. Boone was arrested on February 25th of 2020 after giving a statement to law enforcement. At the time, she purportedly consented for her cell phone to be searched and it was seized. It was purportedly video evidence of Miss Boone's cell phone that led to the filing of the instant charges, the infamous video. Since February 25th of 2020, defendant's been continuously in custody without bond. Neither she or her attorneys have the opportunity to see and review her cell phone or have it analyzed by an independent person. So you will hear this in the video, are requesting an independent review of this cell phone. That's true. She was wanting to get her actual cell phone back. I'm like, honey, no bueno, no bueno. Let me click off of that and click back on this. The counsel on behalf of Miss Boone has timely filed a notice of intent to use the battered spouse syndrome defense. I'm sorry. Let's go back. I forgot. Okay. The thing is, the phone was analyzed by the state, and now they want the phone so they can have somebody analyze it. But the problem is, they're not going to hand over the original phone because there are things that can happen. And one of the things that can happen is they start to analyze it and it gets deleted. Okay. And you're like, oh, well, so they're not going to hand over that. Hi, Lindsay Bay. Hello, Pom Mom. Hi, Corina. Hi, Pickle Knits. They're not going to hand over that phone. I mean, we'll see what the judge says. They're also wanting to use the battered spouse defense. Much of the evidence is in support of Miss Boone's defense, including, I don't know, I've been yawning all day, but not necessarily limited to the battered spouse, is contained on her cell phone, including documentation to support the defense. Oh, well, first of all, her texting her friend and saying he slapped me is not necessarily evidence. Evidence would be videos of him harming her. Additionally, perhaps as essential to her defense, is other potential evidence such as witnesses' names and contact information. They can get all that from the state. The Office of the State Attorney and their assigned agents have this evidence, i.e., said cell phone, in their exclusive possession for their exclusive use and examination analysis since February of 25 of 2024 and a half years. Presumably, the state attorney's office, with their vast resources, financial, technological, and investigative, etc., have had sufficient time to review, analyze all data from the phone and to transfer and preserve all needed punitive evidence without necessary of maintaining physical possession of the phone. Wah, wah, wah. Defense respectfully moves the court for order directing immediate release of Miss Boone's phone. If they can get, I understand the phone's important. It's a vital part of the case, but he's acting as if the state has withheld the phone. Who has asked for the phone? She's had 8 other attorneys. You're her ninth and 10th, and you're sitting here saying that you're basically accusing them of hiding the phone or refusing to relinquish the phone. You're the new attorney. You got to start all over. You can't hold that against the prosecution. Should the court not, why am I yawning? That's it. I want to take some energy stuff. Should the court not grant release of the cell phone, the defense counsel would move for an alternative to examine said cell phone, or to have a defense expert examine the phone to retrieve as much needed evidence to support her defense. Hmm. Oh, that's nasty. Without this evidence, Miss Boone will be deprived of her rights under Florida law as well as federal constitutional mandate. Mm. Momento. I apologize. My daughter's away in college and we're having an issue she's needed mama's help with. So I don't know if the judge is going to allow the battered women's defense, but I know that that thing has been back and forth, and we're going to look at this again. But let's stay here. The phone evidence. For me, the phone evidence to me, what skin is it if they have properly preserved the phone? Do you guys think it's any skin off of the state's nose for them to release that phone? Okay, under the Florida statute, blah, 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 prosecutors shall disclose to the defendant and permit the defense to inspect, copy, test, and photograph any tangible evidence that was obtained from the defendant. Okay, that's fine. Should the defense's counsel and representative not be allowed to obtain Ms. Boone's cell phone or, at the minimum, obtain favorable evidence, not only will the prosecutor's state rules be violated, the rule will become a violation under Brady. Oh, so now you're threatening. So now you're threatening. Okay, we see how this goes. Well, we got you. We see how this is going. Yep. Okay, here's the next motion. This was also filed on the same day, on 9/18. This is an amended motion for declaration of indigency and payment due process costs. Now here comes Sarah Boone, blah, 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 blah. Hereby moves the court an order declaring her indigent for the purposes of due process costs and to support thereof, saying that the defendant has been charged by information with second degree murder, blah, previously found indigent by the court, costs by the courts. Undersigned counsel agrees to accept this case pro bono and has not received any payment towards legal fees. Defendant has been notified of an additional cost that will be needed for experts investigators to fully investigate this case and prep for trial in this matter. However, she's unable to pay the costs. Undersigned counsel needs fully investigate this case. Undersigned counsel feels that the defendant's rights may be severely prejudged if it's not able to fully investigate case. Counsel for the defendant requests the court grants his motion nunc pro tuc, I don't know, nunc pro tunc to August 30th. In other words, date it back to August 30th of 24. The motion made in good faith. Da 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 da. Hello, Gretchen Shea. So here he's asking for her to be found indigent again, so the courts will cover all the cost of all the investigators and all the people that he needs to help prepare for this case. Now, if you remember in the interview that he gave after his very first day representing her in court, he said that she owes him. And now he says right here, pro bono, not received a payment toward legal fees. So he just right there, if Sarah Boone later gets a bill, guess what? She'll come after him because he says right here, pro bono. So we have that question answered. It is a pro bono case. So now we go to the amended motion to appoint a forensic psychologist. Now, this has been going on for quite some time. I think it was either lawyer number 2 or 3, I don't know, I've lost track, has hired a person to come in and start this process, and everything's just been all messed up. Let's see what he's asking on this. We already know who's coming. Moves for the honorable court to appoint for a due process provider to aid in the preparation of the defense in the above style cause as grounds would show. Yes, we know she was charged with second degree. Yes, he's accepted the case as pro bono and is requesting the assistance of a forensic psychologist to aid in her defense. The defendant is financially unable to hire due to her process provider, forensic psychologist, to aid. So he's saying that they need that. The person they're requesting is Dr. Julie Harper, which will be brought on. Harper's has been requesting and has been paid in other court appointed cases, rate of $200 an hour. That's cheap. The undersigned Dr. Julie Harper be appointed at the rate of $200 an hour for work and travel time with an initial cap of $7,500, exclusive of necessary cost allowed by statute. In addition, reasonable coverage for travel related expenses cap at 25. So basically 10,000 is what they're requesting. Court September 3rd, the state indicated it was in no position regarding this request. They want it retroactive to August 30th. So what's happened is this woman has already started working with her. Let's see, I don't get how she gets funding for her case if he isn't pro bono. But now pro bono, either way, yep, your tax dollars are paying for it. He's not lying to the judges. This is now where it is. Owens just doing client management with all of these emotions. Yep, Owens will just have to judge. Yep. Nope. Yeah, I know, right? The poor expert. Exhibit A to James from JHAC. So this is the JAC is just saying we have no skin in this game. They're asking that the tax dollars, the court, pay an upwards of $10,000 for Dr. Harper to assess and and interview and come up with her diagnosis of whether or not Sarah Boone has battered spouse syndrome. And you will hear in a little bit that she's already done this before the court has agreed to pay her. If the court says no, she loses that money or the lawyer loses it. Here's the order amended motion filed on the 18th. Once again, it's the same, the cost. It's just, again, the same thing. Uh, yep, same thing. Amended motion to appoint crime scene reconstructionist and death investigator. Are you kidding me? You have a video. Yes, we know she was charged with second-degree dishonest cancel, except pro bono. The defendant's unable due to her. Okay, it's the same language. This particular person, Dr. Michael Birkland, is requesting to be paid in the other court-appointed cases a rate of $200 an hour. The undersigned Dr. Michael Birkland be appointed a rate of $200 an hour for a cap of 50 hours of work with an initial cap of 10,000 exclusive of necessary costs allowed by the statute, additional reasonable coverage for travel and travel related expenses, a cap at 2,500. So they're asking for 12,500 cap. So if you're looking at just between these two, you're looking at 22,500, not including the 1,200. So that's 34,500 between the investigator that they hired for Sarah Boone when she was pro se. Now with the psychological and the reconstructionist accident scene and death investigator, you're looking at basically $36,000 coming out of that tax dollars money. $36,000. Now, in the morning of the 18th, they filed a supplementary discovery. They were requesting making the following information available to the defense, and that would be inmate tablet communication records. No, she doesn't care. It's not her money. And you're good, baby. You're good. You're good. You're good, Mama. She can take her socks off. I'm getting comfortable in here. Do you know how sometimes you're in shoes all day and you just can't wait to get out? Yeah, that's where I'm at. Um, so this to me is just absolutely in that's insane. But I'm not the courts. So they're wanting all the inmate tablet communication records. I wonder if we can get a copy. I need you to lay down. Lay down. Good girl. Good girl. Copies of items listed will be provided under separate cover. Previous discovery provided includes 1 through 423. Please verify receipt of all pages and notify the office of any missing pages or duplicate numbers of discovery. I clarify. So, this is the notice that was sent to the defendant from the state. Oh, thank you. You're welcome. From the state to the defendant that they turned over all of the inmate tablet communication records, pages 424 through 891. Okay. Yeah, I wish we could get our hands on them. State motion to strike defendant's amended notice of intent to rely on the self battered. Okay, so now we've had battered spouse. Nope, we're not going to do that. Now we're going to do battered spouse. Nope, we're not going to do that. And you're going to see the judge in a minute get pissy. Now, usually when I play these videos, I don't like to stop because it's live. On a night like this, we're going to stop and talk about it. Oh, excuse me. Been in the car most of the day and my body is like, nope, we're stiff. We're not having it. I'm moving. Sensei, give me your paw. I don't need you to get your paw squished. Thank you, baby. My service dog, for those of you who don't know, I'm deaf, and I have a service dog who's under my desk, keeping my toes warm. Okay. The defendant filed amended notice of instant intent to relay intent to rely on the defense of battered spouse syndrome on September 15th. By the defendant's own, oh, wait a minute, defendant was provided discovery over 4 years ago. By the defendant's own admission, her expert, Julie Harper, saw her in 2020. The discovery in the case showed that the decedent and the defendant engaged in alcohol infused spats of violence against one another periodically. There's no more described the criteria for battered spouse syndrome than a mental illness describes insanity under McLaughlin rule. Hey, Ronnie. Aw, you're such a great grandma. You're wonderful. The conclusionary statement that, in particular, the evidence will demonstrate factors that trigger BWS, the physical symptoms experienced during BWS, the distinct behavior and psychological symptoms exhibited by the defendant that are consistent with a person who suffers from BWS. The impact of BWS as it relates to the facts of this case does not set forth particular evidence that shows the defendant suffered from this syndrome. The state concerns what the defendant is alleged does not meet criteria for battered spouse syndrome is not premature. The discovery does not support a diagnosis of battered spouse syndrome, and the defendant is not alleged new facts to support battered spouse syndrome. Battered spouse syndrome is not actually a defense of a crime, and that is true. It is an explanation or a cause for the person to commit the crime. The introduction of battered spouse syndrome evidence to support a self defense theory is not for the purpose of justifying a defendant's misperception of reality or to explain why any unreasonable belief was nonetheless justified due to her condition. Rather, the Florida Supreme Court has sanctioned the use of battered spouse syndrome to show why a defendant's actions were reasonable, to show in spite of a reasonable pre- uh, precipitation of danger from the battered spouse. The battered defendant would remain in the home with her batterer while she may resort to the extortion or force against him to prevent imminent death or greatly bodily harm. It does not excuse the fact that somebody ended somebody else's life during an episode of being battered when there is a pattern of being battered. Like it said, it's not justifying. It's it shows why the defendant's action were reasonable. So if you have a spouse that's been battering and one night they have you against the wall, hands, and you're about ready to pass out, and you grab a knife on the kitchen counter and you stab him to save your life, that's reasonable. This does not fit that at all. Hi, Hilda from Australia. Thank you so much for joining. There's no evidence of a justifiable use of deadly force in this case. That there, my friends, right there is the whole point. Right there. Defendant has not alleged, that's true. The defendant had not alleged uh, any such new evidence of, uh-oh, my bad. Uh-oh, y'all aren't seeing this? Oh my gosh, why is it not sharing? Y'all should have screamed at me. Hello. I, I just realized it wasn't up there. I can't see what y'all see. I apologize. It's up now. So right here, number 9, I'm going to re-highlight it. Let's talk about that. I apologize. I have to have it up big. Let me see if I can do this. I just hate looking sideways to see y'all, but I want to look straight to read. Okay. There is no evidence of a justifiable use of deadly force in this case, and the defendant has not alleged any new evidence in her notice of her intent to rely on the battered spouse syndrome evidence. Hence why they're fighting for the phone, because she's telling her attorney, guess what? I have it on my phone. I need my phone to prove to you and to them that I'm a battered wife. You are a wife, but you're a battered wife or spouse. Were they married? I'm tired. What the defendants told the law enforcement was, when asked about the decedent's other injuries, and all honestly, we had not gotten into it. The defendant said that she and the decedent were having good time on Sunday, having wine, painting, doing puzzles, listening to music. Nobody laid a hand on the other person. I have not touched him. We had a good day. It was okay. I got to do my impressionations because this is exactly what I think of when I hear her. I'm going to read this again. In all on, what? Come on. Where are you?
In all honesty, we have not gotten into it. We've had a good time on Sunday. We had wine, we painted, we were doing puzzles, and we were listening to music. Nobody laid a hand on nobody. I have not touched him. We had a good day. It was a good day. We had good days lately. There was no ill will between us last night. Last argument was maybe last week. I was so happy. Like, it was such a good day. I kid you not. Nobody touched nobody. I said, nobody touched nobody. It's the drinking. That's what it is. It's the drinking. I thought it was. Like, I thought he was okay. Everything was fine and dandy. Why didn't you just let him out? Oh.
Why didn't you just let him out?
To be honest with you, I meant, I don't know. I won't never drink alcohol again.
What was your motivation for leaving him in the bag?
I didn't have any motivation. It was me. He and I were having a great day, fooling around, and being stupid. Apparently, me going upstairs and going, I guess I meant I don't know, and blaming it on the wine.
You two didn't lay hands on each other.
Nope, nope. I don't have any injuries. He and I had not been in at it with another. She didn't do this intentionally. Alcohol is a shitty thing. So it like, okay, so while we were in a good place right now, I'm gonna snap? Is that what it is? While we're in a good place right now?
See, that's the thing, too. But you can clearly tell that I'd been drinking some. Oh, wrong one.
I didn't touch him, nor did he touch me.
Okay, guys, what do y'all think of that? Hi, all. It's the stupid people getting horrible results, in my opinion. Hi, Cat Randall. My print's small. It's hard to read. I know this is so crazy. It's very much so. I've been rewatching her interviews, and I have been watching other stuff, prepping for trial. And as most of y'all know, if you haven't followed me, I'm deaf without my hearing aids, and I struggle sometimes to hear in court. So sometimes it takes me to watch things a couple of times to catch every word. And I have captioning on everything. And I was like, they were letting her run her mouth. A lot of people said that was the worst interrogation ever. But when you have someone like her running their mouth, you shut up, because guess what? They're going to run it, and they're going to run right into a brick wall. Yes, we all need cats. And oh, I have a kitty. No, she did not stop talking, even though they read her rights. And that's the other thing. I rewatched the beginning of the interviews, and they read her the rights off the card, and they stated, "We gave you a card. Did you read it?" She said, "Yes, and I understand." There's a channel on YouTube that has construction workers, and this is the would be one of those situations. Uh-huh. For the defendant, it is the worst. Hi, Jedi Jess. Hey, Jedi Jess. Do you know if there's any way we can get the Sarah Boone tablet conversations that have been asked for by the defense and given to them by the prosecution? So let's continue. See, that's the thing, too. You can clearly tell that I'd been drinking some. I mean, she had been drinking all night, and I just knocked my hearing aid out. There it is. The defendant's account is not one of self defense, but rather an accident. This is huge, because when we go in and watch the video in a minute, this is where the judge and the lawyer are going to get in a little salty moment. And I just watched it 2 or 3 times and ended up giggling over it. BSS is not itself a legal defense, but the evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self defense when the defendant is charged with a crime against her abuser. Oh, thank you. Thank you so much, Jedi. You're phenomenal. We really love and appreciate you. Sarah Boone, me is pissed off so bad that it knocked her hearing aid. Yeah. Um, but this is the thing. She's the one who was arrested for, what was it? A domestic DV. DV. She was arrested for DV. I mean, they both had charges against them, but she's not innocent in this. She is also the perpetrator. This was an this was a bad relationship that just should have ended. Crimes against her. If the defendant has changed her account, she has not alleged such in her amended notice of intent to rely on battered spouse syndrome evidence. It's basically the replacement of the normal, reasonable person standard of self defense. That's exactly what we were talking about a minute ago, but that's a great way to say it. Thank you, Jedi Jess. Perfect way to say it. You know, you can't sit there and scream BSS. So I want to say BS, bull crap, um, in lieu of a self defense situation. Putting somebody in a suitcase and zipping them up. I left 2 fingers whole so he can unzip himself. That's what she said in her interview. I left a 2-finger width hole so he could unzip himself. Okay? That's not self defense. Now, if he was standing there with the beer stein and he was swinging it at her head and she was about ready to go unconscious and she shot him and she was in fear of her life, that's defense. Right, Jedi Jess? Let me know if I'm ever wrong. Don't ever hesitate to correct me. I'm not a lawyer. I am in school for criminal justice degree and considering law school, but I'm not there yet. Therefore, the state renews its request for the court to strike the defendant's amended notice of intent to rely on defense of BSS. It does not set forth with particularity in the evidence that would show the defendant meets the criteria. Additionally, the state renews its request to prevent any mention of BSS until admissible evidence or justifiable use by deadly force is admitted into evidence at the trial and admissible evidence of BSS is admitted into evidence. So they're trying to get it to where they can't bring it up. Defense argument is that the trial court thereby improperly required defense to testify. And where it is imminent of fear of harm to herself, the video didn't sound like that. No, she was not afraid of for herself. Defense actions, unintentional claims kind of throws that out the window. They need to be in fear for their life or desperate to escape before successful. Yeah. Cat Randall, when I was a young cat mom and paw cat would sometimes wake me up in the middle of the night. Oh. Yeah. I'm sorry, cat. So thus far, the state is aware that no evidence supporting the defendant suffered from the syndrome. Only evidence of alcohol-induced violence between both okay, here I'm going to underline this. Evidence of alcohol-induced violence between both the defendant and the decedent. Yes, thank you, Jedi Jess. I don't claim to be an expert. I may have more knowledge than the standard cat. Love cats. I have one too. There is zero evidence that it was justified deadly force. Defendants have stated, okay. Okay, so we have gone through all of that. I am going to share this video. We're going to stop and talk about it. Um, Anybody, especially Jedi Jess, if you want to pop up comments on the screen about this video, feel free to do so. I wanted to watch this because there's several times that the court and the defendant's attorney get catty as hell. Now, there's been a lot of people in this world, male and female, who have had bad experiences in relationships and have been abused. You cannot use the past abuser's abuse on you as a reasonable fear for your life because somebody else is getting loud and mad or whatever and you in their life. No. This judge would, I mean, if we could do it, I would take up a a basket of money and send it to him and say, "Go have a vacation in Hawaii. You've earned it." We cannot. By the way, somebody asked, we cannot. You cannot send gifts, cards, anything to judges, lawyers, or anything of a sorts. Okay, guys? It's hold on a second. I'm having a glitch. One of my I don't know why my video is flickering here, but not over there. But anyway, we're gonna let me see. Where does the volume begin?
Of hearing.
Oh, let's see if I can lip read that. I'll try it later.
Judge, do you want me at the
Sound is
podium?
good for you?
However you feel most comfortable, sir. But because we have your co-counsel appearing virtually, I would ask that you direct any argument into the microphone so that they might be able to hear it, sir.
Judge, as you know, I filed on behalf of Sarah Boone this motion for statement of particulars. And in my motion, I quoted the language in the information that she was charged with. And the pertinent part charges Sarah Boone on the 23rd day of February of 2020. In said
I think
county,
if the
Orange
judge hears
County,
all that again, he's
violated
gonna scream.
statute 782.04,
I
paragraph
think he'll
2,
remember that for the rest
by
of
an
his
act
life.
imminently dangerous to another and evincing a depraved mind regardless of human life, did kill George Torres. Judge, that's about as bare bones of an information as you can file in a case. I know anytime there is a weapon used, it's usually shot with a firearm that was used, that type of language. That is as bare bones. It doesn't even spell out all the essential language of the jury instruction, which I followed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. One, the victim is dead. Two, the death was caused by the criminal act of the defendant. Now, there is no language in the information that alleges what criminal act Sarah Boone committed that caused the death of the victim,
This
Mr. Torres.
Okay, let's stop here. I wanted to get a lawyer's opinion on this because I don't know about this. But to me, does it have to be excessively specific? Is he right or is he wrong? Is it implied? I don't know. The motion for the particulars aggravate me most because there was also a complaint filed that had an affidavit attached detailing all of the things he was asking about. So there is an affidavit attached that's going to explain everything he's asking about. The motion for particulars aggravated me the most because there's also a complaint filed that had an affidavit attached detailing all of these things. So he's arguing, if I understand it right, and I may not, is he arguing it should not be in an affidavit, but it should be in the physical report and not in an affidavit? You are throwing dog, cat, human, bird, every animal of fecal matter at the wall and seeing if it sticks. Hey, guys.
This is a unique case, Judge. It does not involve a firearm, which I believe many of
There's
these
a lot
cases
of
do.
ending of lives that don't
I'm sure
involve a
you're well aware,
firearm.
the state's well aware, the defense is well aware of the report, the videotapes in this case, and the overall general facts about the suitcase.
I'm going to
and Mr.
speed it up
Torres
just
being
a
in
hair
the
because he speaks
suitcase,
slow.
asking to be let out by Ms. Boone. But the state, in their charging document, has failed to say exactly what it is that they believe is the criminal act that caused death by Sarah Boone. Some
Are you
information
kidding me?
that the defense could receive from them so that we could properly prepare a defense for Ms. Boone. In count 3, the unlawful killing of the victim was an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. It goes on to define an act as a series of related actions arising from or performed pursuant to a single design or purpose. We have no information, no particulars in the information that explains a series of related actions arising from and performed pursuant to a single design or purpose. None of that language is in the information that
That's
would let
what
us
I'm,
know
let me
what it is they're
pause
claiming
this.
that she did.
Oh, snap. I didn't want that.
My understanding of the rule of criminal procedure, the defendant has a right to know the charges against them with specificity.
Okay, let's look at this. Jedi Jess, you're so amazing. He's saying the information doesn't have enough information in it for her to know what she is charged with and why, but he ignores the complaint that was also filed. So, do you not have a copy of the complaint? Are you so overwhelmed and apt to handle this that you missed it? Thank you. I agree. I agree. I agree. Yep. That's good.
Upon request, the state must provide specificity and clarification on the details of the alleged offense in order to minimize surprise at trial and ensure that the defendant's rights are protected. The rule requires that the information shall, in plain, concise, and definite written statement of the essential facts constituting the offense charged. In this case, based on the bare bones information that has been filed in
And
this case,
Jedi,
it
Jess,
fails
do
to
you
inform
think
the
it's
defendant
enough?
and the defense counsel
I
of the
do,
particulars
but I'm not a lawyer.
sufficiently to enable the defendant to prepare a defense. Thank you.
Response.
That's all I gotta say.
Judge, the state stands by its written response that was filed on September 5th of this year. In addition to that authority that is cited therein, the state would also cite State versus Pajon, Pajon, 374 Southern 2nd, 1070, Florida 3rd DCA, 1979, and Sutherland versus State, 305 Southern 3rd, 776, Florida 1st DCA, 2020.
Can I have the second citation again? 305 Southern 2nd.
Southern 3rd, 776. And what all these authorities stand for, dating back to well before there were any discovery rules crafted in, I think, 1968, is the position that it's an extraordinary remedy to be given us.
Jedi, we'll look at this after this, but yes, thank you so
The
much.
information in this case tracks the statute. That is what is required. There is nothing confusing about it. There aren't multiple allegations.
The ICJIS arrest affidavit clearly states exactly what they're charging her with and what they believed. Oh my gosh. Yeah. Thank you for that. We'll go over that when this is done.
Of
Yeah, that's
second-degree
more
murder
than
on the same
enough.
day, leaving her
I just glanced at it and
confused
could
as to
see
what we are talking about.
he's
There is
just
no
throwing
exposure to double jeopardy.
dung
There's no
at the
element of
wall.
surprise. The state of Florida has provided discovery to the defendants in 2020. The state waived any opinion work product arguments.
Okay, I just had a thought. Hey, everybody, let me know, including you, Jedi Jess. Do you think maybe he's doing this just to appease her? Because remember, she said her attorneys wouldn't do what she wanted and didn't feel like they were doing enough for her. So do you think maybe he's throwing all this at the wall so she can't come back to him and say he didn't try, being that he's the 9th and the 10th attorney? Could this just be why? So he can say, I threw everything at the wall. I threw at everything we had. And sorry, babe. Honey boo boo, you done got yourself in trouble. I did everything I can and I'm out. I don't know. I'm just guessing. I'm so excitable. You should have met me in my
That it
20s.
had under Williams versus State in going ahead and providing the defendant.
I have seen
exactly
the
which
video,
exhibits we're going to enter
but I haven't
at trial,
dove
exactly which
into
of the
it.
witnesses we've disclosed will be called at trial.
Because remember, I'm
And
reading
their motion
and
does
it
not
goes
set
quick.
forth why it is specifically that they don't understand what she is accused of doing and how. In fact, opposing counsel cited the videotapes, the videos that were taken on her phone while the decedent was in the
So not
sequence
only did we
begging to
give
be
you
left
it in
out.
writing, we gave
And
you the
then
video.
They didn't mention is what she said during these videotapes, which certainly would constitute the mens rea for second-degree murder. So it's our position.
He's like, Your Honor, we gave it to him in writing. We gave them the video. Maybe, but as an attorney, you have the ethical obligation not to file things frivolously or without proper authority to support. That is true. I agree. But this woman is not a normal client. I'm sorry, Jedi Jess. This woman, everything's out the window. Well, ineffective assistance of counsel. God only knows. I would love to interview him.
That they have not stated why it is that a statement of particulars is
Hey,
necessary. It's an
KBF.
extraordinary remedy. They have all the discovery.
You guys,
not only do they have all the
please
discovery, they have the
subscribe.
narrowed down list
Trying to reach
specifically as to
3,000.
what will be introduced.
Please subscribe.
And they
What did I just do?
What was it?
I apologize. I don't know what I just hit.
have all the discovery. Not
There we
only do
go.
they have all the discovery, they have the narrowed down list specifically
right back.
as to what will be introduced. And
Poppy the
they are
Pepper.
clearly on notice of what constitutes the acts and the mens rea, because they have mentioned those videos that were taken on her phone. So it's our position that this is not one of those extraordinary cases that necessitates a statement of particulars. There are cases where, for example, somebody commits multiple acts of battery against a victim, perhaps an hour apart, 2 hours apart, and comes back, and it's unclear as to what the state is talking about. If counts 1, 2, and 3 all say battery on X day, there are informations and indictments that span years that don't get statements of particulars articulated to the defense. In this case, the date is specific as to February 23rd, 2020. The metadata on the two videos that were taken from her phone are both from the 11 p.m. hour of February 23rd, 2020. Given all the discovery in the case and the amount of narrowing down that we've already done, there is no need for a statement of particulars in this case. Thank you.
Thank you. Any response?
My understanding of the law is the court has broad discretion on this issue about whether to require the state attorney's office to give more particulars about the offense. And this is somewhat of a unique case. And the state attorney just mentioned where there was prior incidences of violence or battery that occurred prior maybe to the death, and whether or not that was relevant or admissible. That's the case we have here. Judge, I'm sure you're aware that Mr. Torres suffered from some blunt force trauma that was unrelated to the death. The medical examiner who did the autopsy took photographs and described that there was blunt force trauma on Mr. Torres's body that did not cause the death, that was unrelated to the cause of death. And that information has not been detailed, whether or not it's relevant to his death, whether or not they're going to try to tie that in to Mr. Torres's death. And if not, if we're relying on the medical examiner's explanation of the cause of death, which was asphyxiation, suffocation, then there's a question about whether that information
Is there anything that's missing under the statute? I understand your reliance on the jury instructions, but what's your response to Mr. J's position that it tracks the language of the statute wholly and completely, which it seems to?
Well, I have the rule for motion of particulars then. If that's the case, then in every case in the country, you just have to track the statute. And at no time a court would ever order a motion for statement of particulars.
But the date's there, the time's there, where it happened is there, the underlying charge is there.
I
What's
understand.
missing?
And I explained that this is not a shooting where death would occur fairly quickly after multiple shots, that this was an unusual death, asphyxiation over a period of time, which we don't even know whether it was the day before or the next day. There's questions about that. The injuries, the blunt force trauma that the medical examiner is claiming that they're there, I believe is going to testify they could have been there 24 to 36 hours before. We don't know when those prior injuries were. They're fairly fresh, but they can't state that they were close to the time of death. Again, they weren't related to the cause of death. So there are situations in the law based on the unique set of facts that a court feels compelled. Yeah, I have the discretion, and I feel like for the defense to properly prepare for this case due to this unique set of facts, that I think there are some details that you must give. There's blunt force trauma. We don't know exactly when it was. We know it was fairly recent. And the medical examiner says the cause of death is asphyxiation. He doesn't know where it was environmental or not. He gives two explanations. So there's a real question about that. And of course, we'd like to know what theory they're going under and whether or not they're intending to introduce evidence of this blunt force trauma that occurred sometime prior, and what exactly they're claiming that she did. That constitute, is it just the video, the 2-minute video that everybody's seen, or the suitcase video? Is it that? Because there was a lot that occurred prior to the video. There was a lot that occurred after the video that's not on the video. So is that what they're referring to in this narrow window of just tracking the statute? And I go back to, there wouldn't be this rule in the criminal procedure if there wasn't a time when a statement of particulars was.
Raisin Bran.
All right, thank you, sir. The court has reviewed the motion, reviewed the authorities provided, including the additional authorities, State v. Bijan, 374 Southern 2nd, 1070, and Sutherland v. State, 305 Southern 3rd, 776, and relying on State v. Peel, if the indictment is sufficiently full in its allegations of fact constituting the crime charged to enable a person to plead to it. The greater part of the reason for allowing particulars does not exist. The application was not so much for a bill of particulars as for a detailed statement of the evidence by which the state proposed to prove its case. If the defendant was advised of the nature and the cause of the accusation against him and had notice of the dates on which the acts constituting the offense were
Did I
committed,
just
there was no
think
necessity for the bill of
his
particulars.
having her
All this
attorney
information was given in the indictment.
figured that
That's at
out?
154 Southern 2nd, pinpoint 912. It sounds like, based on your argument, you're looking for the particular evidence as to the cause of death and the meaning of the death, which, based on Peel, is not something that falls under the ambit of a motion for particulars. So reliance on State v. Peel, understanding the age of this case as well, understanding there have been multiple lawyers who have filed responses denying the charges in their notices of appearance, your motion is denied, looking at the totality of the circumstances. Moving now to, give me a moment. And I think we could probably address these collectively. The defense's motion for additional discovery filed September 2, and the defense's second motion for additional discovery filed September 6th. Similar to the first motion, the court has reviewed all the authorities and those motions. Mr. Owens, you may proceed, sir.
Can I approach the bench?
Yes.
Cat, Randall. When you're sitting and hearing someone beg to be removed, to be let out, can't breathe, and you can hear, I'm told, I can't, over a period of time, he's getting weaker and weaker. Doesn't matter if she thought it was going to cause death or not. It did. And she was being revengeful. That's what I got from this. This is what you get for doing whatever to me. This was vengeance. This wasn't playing a game. And that's the way I would see it if I was on a jury, is I would see, if I saw that video, I would see that she was not in self-defense. This was not an accident. This was vengeful. Very vengeful. There was anger, hatred. And the creepiest part is when she goes, shh. I don't know why my computer's doing this, but I got to figure it out.
Judge, we're going to handle these both collectively, and I believe we should. The first motion for additional discovery was filed on September the 2nd at 8:30, and then the second motion for additional discovery was filed on September the 6th. The first motion.
What? Wait, Jedi. Really? Not the first time she's put somebody in a suitcase? Earlier, DCF was called for putting her son. What? That I didn't know. Oh, snap.
Refers to the rule 3.220F for additional discovery. On a showing of materiality, the court may require such other discovery.
If
to
I
the
was
parties as
prosecution,
justice
I'd
may
fight
require.
like hell to get that in.
Specifically, the defense is requesting the
Pattern
office
of
of the state
behavior.
attorney to provide a written policy of the Orange County Sheriff's Office relating to in-house interrogation procedures in particular, the policy in place at the time of the interrogation of the defendant at the Orange County Sheriff's Office, which was back in February of 2020. And then the second motion for additional discovery, specifically, the defense requests the Office of the State Attorney to provide the standardized Miranda rights written policy, the form, and the card of the Orange County Sheriff's Office relating to Miranda rights form utilized and read directly to any suspect before the interrogation. Now, the argument by the state is well taken. The defense does have a duty to try to gather the information independently of the state attorney's office. And we did make a request to the Orange County Sheriff's Department back on September the 10th. And the request was for the written policies and procedures of the Orange County Sheriff's Office relating to the in-house interrogation procedures, in particular, the policies and procedures in place in February of 2020. And the written policies number 2 and procedures of the Orange County Sheriff's regarding Miranda rights, written policy, the form and the card relating to Miranda rights utilized and read directly to the suspect
Ronnie, can you find it for me?
before the interrogation in
Please.
effect in February 2020. So as you know, Judge, I don't know if you've actually watched the 2-hour interrogation, but the day after this event, she was asked to come down to the Orange County Sheriff's Office
What?
under what my client believed was something.
I want to see the video. I don't see it playing. I'm going to try and play the video. Okay, we're going to share this. Let's play.
And charged with murder. And yesterday, Channel 9's Steve Barrett uncovered a picture on Boone's Facebook page of a child in a suitcase. And Steve, you found out investigators have already looked into that picture.
Len, the sheriff told me that 4 years ago, they investigated that very picture of that child in the suitcase. That investigation went nowhere. But then comes this newest case, a death inside of a suitcase of the same person's boyfriend. And the sheriff said that was a startling first for him.
So I've been in law enforcement for 30 years, and when I got the phone call on this one, I had to have my commander repeat it several times because I was just flabbergasted.
Investigators at the Orange County Sheriff's Office were caught off guard as they say Sarah Boone described a drunken game of hide and seek to explain how her live-in boyfriend, Jorge Torres, ended up dead.
Never heard of anything like this, and obviously, the stories that were told to us in the beginning, obviously weren't adding up.
Detectives say they found videos on Boone's phone of her taunting her boyfriend as he screamed for help and is seen struggling from inside the suitcase in this East Orange County apartment. Yesterday, Channel 9 provided the sheriff's office this picture from Sarah Boone's Facebook page of a child appearing to be playfully zipped into a suitcase. The sheriff's office quickly looked into the 2016
Who is the
picture.
man?
That was investigated 4 years ago, and both our investigators and Department of Children and Families realized it was consensual. The kid wanted to get in there. The kid wanted the picture of being in the suitcase.
And so you heard there.
Oh my goodness, y'all. Who was the man? Who was the man? Was that the boyfriend? Oh, okay. Let's keep going.
An interrogation. When she got there, she was directed into a room. And I don't know, like you said, you haven't had a chance, but there are some serious issues about whether or not that was coerced, whether or not Miranda rights were fully read. I do not believe they were. I believe some of the statements that the lead detective said before she started the Miranda rights are coercive. She was in a room where she could not leave with 2 homicide detectives. One was wearing a firearm, and she acquiesced to authority based on an improper reading of Miranda. I wanted to file motions to that effect. We've got trial coming up October the 7th. I wanted to wait to get those policies. I wanted to wait to get the Miranda rights form. The homicide detective actually reads it from a card. And I believe she read it incorrectly and she left out the main question at the end. So the
I
proper thing to do is to get
watched
that information. and
that
make sure it's
video.
verified before
I
you
didn't
file in
hear
good faith a motion to
anything
suppress
left
or
out,
statements.
but I'm not a lawyer.
Well, the state attorney has tremendous power. I've made this request, what was it, September the 10th, now it's, what's the 19th? And I'm in line with other public records requests there at the Orange County Sheriff's Department as to when I get this information. The state attorney could have gotten it the very next day if they would have made that request. That's why I filed the specific motion for the additional.
Let's watch
I'm gonna
this.
have you sit the green chair that doesn't move.
That's a little loud.
Yes, ma'am. And I want to ask you about the room. Sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And since I'm talking about the incident, we just have to do it, just like we did yesterday. Just like we did yesterday. Remember I read you the rights, your rights? Yeah, so it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? Sure. All right, so you have the right to remain silent. Anything you say may be used against you in court. You have the right to talk to a lawyer before and during questioning without charge. If you cannot afford a lawyer and want one, one can be provided for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? No. And do you understand what I just read you? Yes. Perfect, okay. So this morning we went to his autopsy, and we were informed of some injuries that.
Okay, Jedi Jess, or anybody else in the chat who have any legal experience more than me. Was that proper? I'm going to be doing some beadwork while we're listening. I thought that was proper. Oh, the last question? What's the last question? What's been left out? I may be in the wrong. I get it. But I want to know what's been left out. Anybody know? Okay, you don't have to speak to us. Anything you say can be used. Well, okay. But that was, I thought so, Jedi. I thought I've heard the Miranda being read to people on the side of the road more times I can count. I don't understand why this lawyer is throwing this crap at the wall. You agree? Did you agree to speak with me today? Yes. Okay. Let's get back to the argument.
We've got about 18 or 19 days left for trial. I'm still waiting. I've still got to receive that information. I've got to file the motion. I've got to set it for a hearing. I've got to subpoena the two homicide detectives. We've got to have a hearing with 18, 19 days left. I'm still waiting on this information from the sheriff. I've made a good faith attempt.
Yep,
Time is ticking.
that's what I think
The
too.
state could get that information to me tomorrow. Thank you.
Response.
Your Honor, it's not Mr. Owens who's on trial, it's Sarah Boone. Sarah Boone was interviewed by the Orange County Sheriff's Office on
Hello.
February 24th and 25th of 2020. Now, some 4 years and 7 months later, there's this exigency not created by us, created by them. It's the defendant who has not done this for 4 years and 7 months. Now, turning to the merits of this, they are asking for discovery from a third party. Any discovery request, whether it is of the state or of a third party, has to involve allegations that this information is reasonably calculated to lead to admissible evidence or be pertinent to some analysis in this case. They have not stated why in their motion, and the arguments in court today do not state why it's pertinent either. The case law does not say statements are inadmissible or only used for impeachment if the law enforcement officer violates policy. There's no case law that says statements are inadmissible or only used for impeachment purposes if they don't read from their Miranda card properly. What the case law states is statements are inadmissible if there are Miranda violations and only used for impeachment, or if statements are involuntary, basically through promises, then they can't be used for any reason. But nowhere in this analysis does it matter to any degree what a standard issued Miranda rights card looks like or what their policy is on interviewing. What they do have and what the defendant has had since February or April or whenever discovery went out in 2020 was a videotape of these interviews. There has been absolutely nothing stopping anybody from filing a motion to suppress if they believed under the case law, relief could be granted under the law. And the law does not have any analysis regarding standardized issued Miranda cards or policies of law enforcement agencies. And I don't believe that's admissible at trial either. If they did not violate the Constitution of the state of Florida or the United States in compelling an involuntary statement or by violating the dictates of Miranda versus Arizona, then questions about whether they read from their right standard card or if they violated policy should not be admitted in trial because it does not help the jury understand whether or not an element of the crime has been proven. It's not a part of the lengthy jury instruction now that we give about defendants' statements. There's nothing in there about, well, did they violate their Miranda card? Did they violate their policy? So first of all, the state's position is they have not asserted the materiality needed to get discovery ordered by this court, which would be reasonably calculated to lead to admissible evidence or to lead to it being found inadmissible by the court. And then secondly, it's on them to conduct this discovery, and coming in and saying that I can snap my fingers or not snap my fingers and get it for them instantly isn't evidence either. So it's our position that their request should be denied, primarily because it's immaterial, and then secondarily because it's on them. She's been aware of these statements since February 24th and February 25th of 2020. Thank you.
Thank you. Response to the materiality, please.
Because I believe the prosecutor is wrong. One of the jury instructions, standard jury instruction in criminal cases said that essentially a statement has been placed before you that's made by the defendant. And I don't have the language here, but it should be weighed with great care and caution to make sure it was freely and voluntarily made. These are some, but not all of the circumstances that you should consider in deciding whether or not the statement that was made by the defendant was freely and voluntarily made.
I'm going to read what Jedi Jess has written because Jedi Jess is so wise. Wise you are, sir. To clarify what's going on, in the defense requested a copy of the card and the policy for reading them conducting interviews. True. Neither item matters if they were moving to suppress the statement because if Miranda is violated, what's one of the card policy doesn't weigh on whether the statements are excluded. Gosh, I like having you aboard. Wise you are. Thank you. Thank you.
If you decide that it was not freely and voluntarily made, that evidence should not be considered by you in this cause. So even if we filed the motion, we got the information, the additional discovery that we need in good faith for me to file it, if we received the information, I typed up the motion, we had a hearing, the two detectives testified, and the court ruled that the statements were not suppressible, I could still bring those facts into the trial of how the mistakes that were made by this lead detective in the coercive statements that she made, as well as not giving the full Miranda rights form and getting a full consent from my client, that goes into evidence for the jury to decide whether or not to consider the statement at all. Thank you.
So where's the violation of the Constitution then?
I love this.
Assuming you're
Salty
correct,
moment.
And assuming that the Miranda card, something was missing, what's the issue?
It's coercive. The statements that the lead detective, the female detective makes, there's 2 or 3 statements she makes.
Now you have to understand, I'm in a vacuum here because I haven't watched the video. I'm not asking you to play
I
it,
probably should have.
but I need a little bit more context as to these statements because I have unfortunately no
them
frame
right
of
here,
reference.
but she says that, number one, the date of this event, they seized her phone at the scene. She was told that they were going to bring her phone back to her, back at her apartment, the very next afternoon. The female detective called her, or Sarah called the female detective about the phone. The female detective said, I'm pregnant, I'm not feeling well, I don't want to drive out there to give you your phone. Would you please come to the sheriff's department so that we can give you your phone? Sarah came back in and saw that there was a desk or a place there to retrieve the items. And she saw the male detective and said, is this where I go to get the phone? He said, no, we got it back here in this room. Come back here in this room and we'll get it. When they walk back in there is when the video turns on, and now they're in the interrogation room. She's got a list. Sarah Boone has a list of things that she was wanting to ask them. And the female detective says, look, we got the autopsy back from the medical examiner. we've got to talk to you about that. 2 times she said, we must, I don't think it's must, we've got to talk to you. She goes, okay. So I got to read you these Miranda rights again. And
Again,
she had read them. There was a statement that Sarah Boone gave. Of course, she gave a general statement to the first deputy that responded to the scene. She was wearing a body cam, so that deputy had called the 2 homicide detectives, but it took them a while to get there. So she asked Sarah Boone what had happened, and Sarah explained that situation. After the detectives got there, they took a general statement from Sarah, but at some point they got into one of the squad cars. And I believe it was Sarah Boone. I believe it was the female detective and the male detective. And she was read Miranda rights, again, incorrectly, and she gave a statement. So now the next day, she's back in the interrogation room with the 2 deputies, the 2 detectives, and the lead detective says, we've got to talk to you about this autopsy, giving her the impression that's what they were going to talk about. But I've got to read you these Miranda rights. And she said something, and Sarah said, protocol? Because they had told her in the first Miranda rights that this is just protocol. We have to do this before we speak to you. And she said, yes, protocol. So based on those statements that we've got to talk, you have to talk to us. We've got the autopsy. Led Sarah to believe that they're going to talk about the autopsy. In addition, then she starts in the Miranda judge, she made a mistake on it. I don't know if it's an honest mistake, but in her probable cause statement, she said, I read the rights verbatim. The constitutional Miranda rights, I read to her verbatim. That is not true. Fortunately, we have it on audio. Fortunately, we have it on video. There is a legitimate question about whether that statement, that 2-hour interrogation, is admissible in this trial.
Yes, exactly,
That's what I'm going to
Jedi.
show the court.
File a motion to suppress it. But here's the thing. If I'm mistaken, let me know. But aren't police officers, investigators, to a certain level permitted to lie in an interview to gain valuable information in a case? I don't know where the bounds are for that. I've not gotten to that part of my education. But is it not true that they are permitted to, within a certain bounds, not provide truth? I don't understand how it's playing so stupid. He knows better than, yes, he does. But once again, it's on behalf of his client. You know, sometimes when you're so screwed, you got to try to get creative. And sometimes that creativeness turns into stupidity. And this cat, my kitty, has decided my toes are her new toy. So if you see me jump out of this chair, don't be alarmed. I'm just going to chase a cat out of the room. I exactly. So why is he upset that they lied? He knows they can lie. This is true too. Very true. Very true. He may not be as well. He seems, if you read his resume, very, very experienced. Yeah. Well, the thing is I'm moving my beads out of my reach of hand because if I go flying, I've already dropped them 3 times the other day. These are seed beads. They're teeny tiny. All right, let's get back to it.
Court. I'd like to get their policy just to see.
what does the policy have to do if those statements were inadmissible?
It
What does the
doesn't.
policy have anything to do with that analysis?
To see if they,
Because if you're saying you have a deposition, I'm assuming it's a deposition of the female detective, said I read it verbatim, and you're
no,
telling,
that's the in the probable cause statement.
okay, that it was read verbatim, okay,
Yes,
excuse me.
formulated the arrest report. It was a supplemental report or either the actual probable cause report.
And the representation in there is, it was read verbatim.
That's
Now,
correct.
you've reviewed that interrogation. It's your position that it was not read verbatim. What does the policy have anything to do with that issue?
I think,
That's a simple constitutional issue, right?
yes,
If there's a case law that buttresses that position and that de facto is a violation of the Constitution, ergo that confession or statements are not admissible because of the violation of the Constitution, What does the policy or the Miranda card have anything to do with anything if you have the video and the audio?
Well, the Miranda card is going to show that she actually omitted the last question. Okay? So the Miranda card is there for a reason. I don't know if they have them in the interrogation room or every deputy or homicide detective is issued that card, but it's a small card. But I believe it's going to say on there that you got to get the
No.
waiver. There's two questions at the
I
end.
thought
which
it was
is,
a
did you
10 by
understand the rights that I've just
15.
read to you? And the next question, understanding these rights, do you agree to speak with us now? That question was not read. It was omitted. I don't know why. She's sitting there reading it, and
Does the fact that that question was not read impact constitutionally under case law the admissibility of those statements?
I believe so. Along
That doesn't
with the
answer my
right to
question.
say-
Respectfully, that doesn't answer my question. I understand what your belief is, but where's the case law that you can provide to the court?
I'm not ready for that, Judge.
Okay.
I'm going to file a motion to suppress, and I'll supply you with the case law, but I'm not ready for that. But the reason I wanted the policy, getting back to your first
Why
question,
are you
is
bringing
because
it
I'm sure the
up
policy
if
is
you're
gonna
not
say,
ready
you
for
don't
it?
make any pre-Miranda statements like, we've got to talk. We've got to talk about this autopsy. Those type statements are improper, that they're used to coerce somebody to
Dude,
talk. And I
They
understand the
can
detective.
lie.
They had these videos, the 2-minute video and the short second video, and they had found it on her phone. So the homicide detective was chewing at the
No,
bit
he is not
to get her to talk. So
stupid.
she was trying to induce or influence
He's
her
got a
to
huge
speak to them
resume.
and to not exercise a fundamental right, not to speak to them without a lawyer being present. So she made those two statements preliminarily
Judge is
that I
not
believe the
having
policy is
any
going to
of
say
it.
you don't do.
Mr. J, anything else, sir?
Just the Orange County Sheriff's Office doesn't set the policy for what is admissible evidence in court. The United States Supreme Court does, the Florida Supreme Court does, the 6 DCA courts do, and then ultimately, following their guidance, you will decide whether or not a statement is admissible in the state's case in chief, or if it's only available for impeachment. But whether or not, let's say hypothetically, she read the Miranda card 100% accurately, she followed policy 100% accurately, the state of Florida can't come in and say, Judge, I know they violated U.S. Supreme Court case law, but they followed the sheriff's office's policy, so these statements are clearly admissible. And the contrast is exactly the same. Whether or not they followed policy or read the Miranda card accurately has nothing to do with the analysis as to whether these statements are going to be admissible.
God only knows
or only
why.
admissible for impeachment. And I don't believe that under the case law, they can come in if those statements are admissible and argue to the jury. They violated policy. They didn't review, they didn't read everything on their card. They violated. How does that help the jury decide whether or not the statement's voluntary? It doesn't matter what the policy is. It doesn't matter what the card is. What matters is whether or not they say the words that are required by the United States Supreme Court or the Florida Supreme Court or the 6 DCAs. That's what matters. That is what determines the bar for the admissibility in the case in chief or impeachment.
Okay, thank you. All right, thank you both for your arguments and your positions. In reviewing the authority provided by the state,
Yep.
which the defense has conceded is taken is what it is. I think state versus right is the guiding light for the court here. 803 Southern
Exactly,
2nd,
Haley
379.
Mouse. She's been arrested
In reviewing that
before.
analysis, the defense has
Policy
put
is
forth
not
an effort
law.
to do so. It's not up to the state to prove up anything for the defense. At this point in time, both motions for additional discovery are denied in accordance with State v. Right. Moving now to the defense's motion to appoint forensic psychologist filed September 2, and defense's motion to appoint crime scene reconstructionist and death investigator filed September 2. I did receive JACS's response in that my judicial assistant confirmed that they are not asking to participate in this hearing. And we did confirm that earlier this week. Similar to the other motions that we've heard today, I have reviewed them. Mr. Owens, you may proceed with anything else, sir.
Judge, I have filed the amended motion for declaration of indigency and payment of due process cost.
I did see that, sir.
And then there are 3 motions. I don't know if you got the third one.
Are you referring to the motion to return property?
No, relating to cost. Relating to
Don't
cost.
know that I have. I'm just going by what the notice of hearing reflected. So no, I don't.
I filed a second amended notice of hearing. I don't know if you got that.
Was it forwarded to my office? Because if it wasn't, I don't know.
I'll
if I
have to
got it
ask
yet.
Margaret. I don't know.
Okay.
But I filed a second amended notice of hearing.
You
Can
should
I-
know.
Can I
Please.
get my copy?
And Mr. J, have you seen that, sir?
Dog in fight with the expert.
Understood. Thank you.
Judge, what I had
That's
done.
right,
was I-
Ronnie.
Here, Counselor. What was this sent? The certificate of services contains no date.
He knows her rights.
It was filed this afternoon.
Okay.
This morning.
Okay. right, what is the other motion related to costs, sir?
Well, there's one for the appointment of the forensic psychologist, Dr. Julie Harper, and it's non-pro-tunc. I'd like it to be retroactive to when I actually had to hire them, as you know.
Because we
being on
had
the
them.
case late, August, I believe, August the 30th.
That's correct.
And then it,
That's pretty presumptuous of you to sit there and have a woman start providing services with the forethought that you were going to request the court to have some, the court or the county pay for this expert, but you go ahead prior to requesting the court to pay for the expert. You go ahead and tell her to start. It's okay. I'll have it retroactivated. I'll have them backdate the pay. What? Boy, you got cojones. I understand you're under the gun, but dude, you're sitting here asking the court to pay for work already done before you even get consent from the court to even do it. I don't know if they normally do that, but that to me is presumptuous.
I asked Dr. Harper to go down and see Sarah Boone. Dr. Harper lives in Okaloosa County, and she came down to Orange County, I believe, the Thursday after we had the hearing on September the 3rd. I believe that's when the court denied my motion to continue. And so, as you know, we had to file the notice of intent to rely on battered spouse syndrome within 30 days prior to trial, which would have been that Saturday, I believe. So she went down, Dr. Harper went down and saw Sarah again. As you know, Dr. Harper had seen her several times early on in the case, back in 2020, maybe 2021. And so she had the most knowledge of, I believe, any of the experts that have evaluated Sarah Boone over the course of these 4.5 years. She was the one expert that had seen her the most. I asked her to go down again in the hopes that the court would appoint her, and she agreed. That was, I think, on a Thursday. She called me that morning, Friday morning, and said, yes, I do believe that she suffered from battered spouse syndrome at the time of this offense. Based on that, I filed the motion. But so she jumped ahead and did some work.
She jumped ahead.
Prematurely before she had been appointed. So I'm asking for those costs for her to do the earlier work, that be considered, as well as Dr. Berkland. Dr. Michael Berkland
So we're
is
asking you
crime
to
scene
backdate this.
reconstructionist and death investigator, and I'm asking for the court to consider paying for his fees as well as his transportation costs, as I have for Dr. Harper, again, to be retroactively to the time I asked him to begin work on the case. And then the last,
When was that? You're asking non-proton to win on that, also to the August 30th date of your
Yes.
appearance?
if possible, yes. That's when I officially got on the case.
Now, as to the third motion for cost, I don't have a copy of that, unfortunately. Yes, please.
Judge, I mentioned this expert, Dr. Michael Brannon, in that hearing that I think we had on September the 3rd. He's a clinical psychologist. If you'll recall,
But is it
I mentioned
appropriate
him. He had
should I,
served as
for
an
an
expert
attorney
in
to tell
Marsha
people
Thompson's
to
Palm Beach
start
County
working
case.
I recall.
when you know
And
you're not
so,
going to
as
pay
you know,
them
he serves a different role
and
as
you're
a
going
clinical
to, let me do
psychologist.
this. So is it appropriate to ask experts to start working on a case when you know that you yourself personally aren't going to be paying for it and you're going to be petitioning the courts to cover that cost? And you haven't even done so yet? I know I'm asking a little weird. That's my dyslexia kicking in. I'm trying to think at the same time I talk, but I'm a little confused. Being detained can be the officer simply stopping you and walking down the street in a road or even a traffic stop, especially at any time you're not free to leave. Yeah. So what I'm wondering is, I think that they go ahead and agree, but was it risky? In my humble opinion, it is for him to tell the expert to go ahead and start work, but I'm not going to pay you and I'm going to be asking the court to backdate it. You may be out of money. Are you okay with that? I'd say, hell no. You cover me or the courts cover me, but I'm getting paid.
Dr. Harper is serving as a forensic psychologist. And
Do you know what JACS's opinion with regard to the motion to appoint clinical psychologists? Because the email that you attach as Exhibit A to that appears to be Mr. Lake's email regarding the other two motions.
Jay Hatch doesn't want to
regarding
be
Dr.
a
Harper
part
and
of it.
Dr. Berkeley.
They have
And it
no,
doesn't address Dr. Brandon, and
dog in
notably
the hunt.
JACS isn't here.
we just read that.
I don't have an answer for that. Maybe we could table this.
I think the state has, I'm assuming, no dog in this fight, similarly as they had with the other two.
Correct.
The request in this area that the state is going to make of the court is to, under its discretion under 3220, order these experts to produce written reports. We are on the eve of trial. I do not need one from Dr. Julie Harper. Her deposition is set October 1st. These two other people, I have absolutely no idea what they're going to say.
Yeah, but
I'll file a written
I
motion
just
and
think
proposed
it's
order and opposing counsel.
the expert may be okay with it, but why would the court be
I don't know if I'm
obligated
gonna
to
have an
backdate
objection
it?
to a written report or not. I may.
That's
but I'd like to see
presumptuous
what
that the
motion
court's
said.
going to cover it.
And
Make a
I'm not,
decision. But yes, Judge, we have scheduled Dr. Julie Harper's deposition at her office in Okaloosa County on Tuesday, October the 1st at 10:30 a.m. Eastern Standard Time.
is that in person or is that virtual? Is that in person or is that virtual?
I believe it.
Okay.
The state's flying in, and I'm going to be their judge. That's the county over for me, Santa Rosa County. So about an hour drive for me. So I'll be there in person. We're going to have
Just
probably,
say
Kevin
in
Beck
person
that's gonna
or
appear by Zoom.
virtual,
All right, so here's what we're going to do. JACS has provided their response.
that I'm going to
and
be
their
working on
response
for
was
the
not
next
appended
9
to
months.
The motions that were filed, because that was prior to the amended motion seeking indigent costs that you filed, Counselor, on behalf of Ms. Boone. I'm going to hand file with the court now the September 9th correspondence from JACS reflecting that that can be utilized in lieu of a formal response. I'm going to grant your motion to appoint a forensic psychologist dated September 2, 2024, non-protunct those costs to August 30, 2024. And with regard to the other motion,
I think he was gracious on that.
the motion to appoint crime scene reconstructionist and death investigator, I will also grant that and appoint Dr. Michael Berglund, non-protunct, to August 30, 2024. With regard to the motion to appoint clinical psychologist, when was this motion filed? Similarly, the certificate of service does not reflect a date.
Let us check real quick. Judge.
Sure.
Give me a minute.
Yeah, you're good.
Excuse me. No, it had to be filed.
While you're waiting on that, I do see on your second amended notice of hearing, you also requested the amended motion for declaration of indigency and payments of due process costs also be heard. When was that motion filed as well, Mr. Owens?
It was filed just prior to filing these amended ones.
Were the-
It had to be filed prior to my motions for appointment of these experts.
Give me a second. Okay, so the motion to appoint the clinical psychologist regarding Dr. Brandon, was filed. Yesterday, the amended motions regarding Dr. Berglund, an amended motion regarding Dr. Harper were filed yesterday, as was the amended motion for declaration of indigency and payment of due process costs. That motion has not yet been granted. It is going to be. So
Sorry,
the amended
guys.
motion for
I had
declaration
some
of indigency
monitor
and payment of
flickering
due process
going on.
costs is granted. The amended motions regarding Dr. Berglund and Dr. Harper are also granted non-protunct to August 30. With regard to the motion to appoint clinical psychologist filed 9/18, I'm going to ask Ms. Barrios, my judicial assistant, to forward that directly to Mr. Lake. And I know that she's watching this virtually. If she's able to do that now, I would greatly appreciate it, and see if we can get his response to that this afternoon. And maybe we'll be able to address that. It may be a similar vein as to the prior response that JACS had provided. Moving now to the motion for return of property, or in the alternative, motion for independent exam by the defense, filed September 18th. Similarly, with everything else, I've reviewed that and the authority, and I have reviewed the state's response to defendant's motion for return of property, or in the alternative, motion for independent exam by the defense. Mr. Owens, you may proceed, sir.
My monitors,
Judge, I believe the
two of
state's
them
response
are
is well
flickering,
taken.
but the main one's fine.
And I
I think
believe
it's
that what we need
cords
to
that
do
came with
is
them are
get
not
an
very
expert of our
strong.
own that can do the phone extraction and meet with the state attorney and the sheriff's department and extract the data, all the data that we need from her phone.
Oh, here we go, yo.
So we would submit that the property should not be, based on the authority the state attorney has cited, the property should not be returned to the defendant since trial is still pending. But in the alternative, we're asking for an independent exam by the defense.
Response, if any.
As the state has stated in open court while she was pro se, that is absolutely fine. And I've even suggested a name.
Has the defense ever performed an evaluation of the phone? And the reason I ask this is there were prior experts that were appointed in the realm of electronic evidence.
Mr. Cacciatore may have to answer that question. I don't, but I know that the state, as I stated in my response, we've
I don't think
never
his
prevented anybody
attorney
from doing
has
that.
all of his
And
ducks
as
in a
the
row
site
yet.
supervisor, everybody in the unit knows how to go about doing this and allowing a digital forensics examiner hired by a defendant to go to work with the law enforcement team and get another imaging if they are not satisfied with the imaging that's provided.
Mr. Cacciatore, good afternoon, sir. Can you hear us? And if you can you announce your presence for the record, please?
Where are you?
There has not previously been a forensic exam of that phone by a previous defense counsel.
Okay. All right. Thank you very much, sir. There was a John Sawicki that was appointed back in, not appointed, authorized back in 2020 as to electronic evidence. So I'm going to deny the motion for return of property.
Yeah, sound is
based
awful,
on the
guys.
citations,
Thank you for the
contained
warning.
in
Woo!
the state's response. And I'll leave it up to you, Mr. Owens, to do what you need to do in order to have that review.
All right, I'm gonna do my best. We got about 18 days.
I'll cite to the parties for their own benefit.
Keep throwing that.
There
I
were
only got
motions,
18
specifically
days.
Defendant's motion to appoint an electronic evidence expert.
Yes,
in
it
order
gets real
the
bad.
Justice Administrative Commission to pay costs was filed back on May 5, 2020. An amended motion was filed the next day, May 6th. Both of those cite to or refer to John Sawicki, S-A-W-I-C-K-I, electronic evidence expert. And there was a order entered back on August 3, 2020, appointing Mr. Sawicki as a forensic specialist. I have no idea if that order is still viable, but I'm just providing what the court file reflects in that regard. Lastly, that takes us to the notice of intent to rely on the defense of battered spouse syndrome. The original notice was filed
Okay,
September
here's going to
6th.
get good.
The state's original
Y'all
motion to
ready?
strike was filed September 9.
Just interrupt. I also have this defendant's motion for enlargement of time to address as well.
Yeah, I have that on my list, sir.
Okay.
Thank you. Thereafter, on the 15th, an amended notice of intent to rely on the defense of battered spouse syndrome was filed. On September 13th, the defense's response to the state's motion to strike defendant's notice of intent to rely on the defense of battered spouse syndrome was filed. And then I think it was this afternoon. Earlier today, the state's motion to strike defendant's amended notice of intent to rely on the defense of battered spouse syndrome was filed. The court has reviewed all of those and all of the citations contained therein. Mr. Owens, you may proceed, sir.
Judge, I wanted to start my argument, and then Mr. Henderson, who is on the screen, is going to respond to the state's pleading that they filed this afternoon.
Mr. J, you have any problem with that?
I know there's a rule in the circuit about one witness per one attorney. I don't know what the administrative rule says about arguments. Discretion of court.
Okay.
He's arguing that one motion that they filed this afternoon, that I've been working on these. He was working on that motion, so it's a separate motion.
The motion to strike.
The last motion whatever motion they filed today, Mr. Henderson, Tony Henderson here in the screen wants to respond to that. I'm going to respond to the ones that were filed prior to today.
All right, I'll allow it. All right, go ahead, sir.
Judge, as you know, I filed my notice of appearance on August the 30th, I think 38 days prior to trial.
I am so
Knowing
tired
that
of
you had
hearing
already made a
that.
ruling
Tired of
that,
hearing it.
You would not grant a continuance unless there was some type of exceptional circumstance. And Sarah Boone hiring or retaining or somebody pro bono coming on the case and representing her did not constitute exceptional circumstance. And so, as you know, We had the hearing after I'd filed the notice on August 30th. We had the hearing on September 3rd on my motion to continue. The court denied it. At that time, I explained to the court that I believed after my meetings, I think I'd had 4 with Ms. Boone, that she met the criteria for battered woman syndrome, but that I needed an expert. And we were vetting several experts at the time, 4 or 5 that we were vetting, and we needed more time to essentially pick somebody to go out and do an evaluation, an assessment of Ms. Boone to determine whether or not they would give an opinion that she suffered from that. Because, and I understand, the court denied our motion, so that left us with, we still had to give notice to the state attorney.
Oh,
30 days
I wanna
prior to
talk
trial,
about that.
October 7, which I believe.
Now, I don't remember where I saw it. If you guys have a better idea where it is, let me know. But I saw somewhere, heard somewhere, some report somewhere that they went through those 5 people, and the only one who would say that she met the criteria for the battered spouse syndrome is Dr. Harper. So to me, that tells me they were fishing. And I mean, from what I've understand and what we've talked about, she does not meet the criteria for a battered spouse syndrome. And I hate that because it says spouse, not girlfriend, not boyfriend, but spouse. I think they probably should change that to partner eventually in the law. But to me, I'm sitting here going, Sensei, no. They took a lot of time trying to find somebody, and the only person they could find was Miss Harper. So that was my little story, and I'm going to stick to it. All right,
Was going to be
lay
September
down.
7th, which fell on a weekend, which was that Saturday, I believe. So we got out of the hearing. I think the hearing was on a Tuesday. We had 4 or 5 days to file this notice, timely file
Yes,
notice.
but when you're
So
this
looking at the
close to
file, I
trial,
realized that Dr. Harper had the most time with Sarah Boone. Early on in the case, I think when Mr. Padilla was handling the
Yep.
case, she was appointed by the court to do an
Oh, yeah.
assessment and evaluation. And so I reached out to her, and she agreed to come down.
look at the Carly Gregg trial. Look at the expert they had. He got his report handed to him on a silver platter by the prosecution.
A couple of days after we had that hearing, and she met with and assessed Ms. Boone. I've retrieved all the notes, the prior
True
notes, and
Jedi.
then the notes from that meeting. And then on Friday, I spoke with her, that Friday, which I believe was the date that I filed this notice, September the 6th.
I want to know, can you
Friday,
file
I spoke
battered
with her on
spouse
the
if you're
phone,
not married?
and immediately went down and filed the notice of intent to rely on the defense of battered spouse syndrome. We made allegations
I'm being
that
facetious.
Dr. Harper had formed the opinion that at the time of this offense, that Sarah Boone was suffering from battered spouse syndrome. And at that time, we gave the name of Dr. Julie Harper and her address where she could be found and located. And of course, the state has set her deposition for October 1. Now, the state has filed a motion to strike the notice of intent, alleging that we didn't give sufficient facts or evidence. But Judge realized at the time, I was simply trying to get it filed because the last day was the next day, Saturday. And of course, I had just gotten discovery. Judge Creighton, we have not finished reviewing all the discovery in this case. I pretty much shut my law practice down to try to do it. I've gotten my staff, and we're trying diligently to go through all the discovery. At the same
When?
time, we realize that we've got to establish corroboration of the battered spouse syndrome from eyewitnesses, from medical records, from potentially neighbors, court records, her phone. and the
That
information
judge
on the
is
phone.
probably
we're
trying not
diligently
to
trying,
smile.
Number one, to review all the discovery, which still has not been done. At the same time, trying to locate additional evidence that we could utilize in helping to establish the battered spouse syndrome. In addition, the state attorney yesterday filed a notice that they're amending their discovery, and all the jail phone calls, or I think they have the ability not only to call, but they have a tablet and they can text back and forth with third parties, that they have disclosed that they have, I guess, 4.5 years worth of communications between Sarah Boone and parties on the outside, and that some of that may be relevant to the case. And we were advised that when I got in town that I was to
But
bring
why
a
was he
CD.
willing to
And I
help
did this
her?
morning. I went to the state attorney's office and spoke with the secretary and explained to her that here's my CD. I'll wait. And I was willing to wait in the lobby to get this additional discovery when we have 19 days for trial. She told me that there was quite a bit of it, that she would try to get it to me after the hearing or by the time of the hearing. I said, okay. I left the CD. I told her she had my number. She could text me. I was staying at the Hilton across the street from the courthouse. As soon as she had it,
Yeah, that's
I wanted
right.
it as soon as possible.
You're
A
right.
short time later,
Future.
they have started, I guess, going
Yes.
through that material, and now they're sending discovery through email. I assume instead of the CD, they're going to do it that way. But we are receiving it. But it's just the volume of discovery that we have to begin with, we haven't gone through. The evidence we're trying to gather to corroborate our defense, and then additional discovery that we were noticed about
Yep.
yesterday.
You're right.
I didn't have time. I knew this had to be filed. I had one more day. As soon as Dr. Harper told me on that Friday,
You
I
could
knew I had
ask
until
for an
Saturday. I filed it.
extension.
The state knew. They've had it 4.5 years. They prosecuted the victim in this case, George Torres, at least 3 times. I think there's more like 4 or 5 times.
That has
But they
no,
opened up a file. They prosecuted it here in this county.
that has no, what's the word I'm looking for? Weight in this case whatsoever. What the victim's background was in this part of the hearing. You knew it was going to be this way. You knew. And if you didn't, then you're stupid. And maybe this is why you should not answer a hand-drawn, cartoon, inmate-made advertisement for an attorney. It said she was forthcoming. Give her 100% of your devoted attention and time. Be able to work with her, ... And now you're complaining. Dude, you screwed yourself.
For battery
No, I hope he's not.
and violating the conditions of
But
bond
they take it
relating to
under
staying away from
advisement.
Sarah Boone. But battery on Sarah Boone. They, if anybody, was well aware that there was a potential problem with the habitual nature in which Mr. Torres beat on my client.
But they also knew she beat on
addition,
him.
My client expressed in the interrogation, which I know the court hasn't seen, please look at the videotape. Please look at my phone. Please look at the videotapes. Please look at the photographs. I need my phone to show you. He comes at me. It was ignored. They've had all this evidence. They had to be on notice that this was a potential issue. And the reason being is all the lawyers that have been through this have appointed different forensic psychologists to assess her. The prosecutor that's not here today, that was here on September 3rd, when I mentioned the problems that we were going to have, getting an expert this quickly to form an opinion, said, oh no, Judge, we're not prejudiced. We've already got an expert. We intend to rebut any said opinion by an expert that she suffers from battered spouse. We're ready to go. We've got our
Yeah,
expert.
go look at his website.
Such that they said, we don't even need a continuance. If in fact he finds somebody and they file something, a notice of intent to rely on battered women syndrome within the time limits, we're ready to go. We don't need to continue it. We'll have our expert. And as you know, they're requesting that their expert now be allowed to go to the Orange County Jail and assess Ms. Boone, which they have every right to do, since we have filed this notice. But they indicated they would not be prejudiced. They indicated they were on notice. They didn't think it was going to happen 4.5 years, but it did. They knew all the prior abuse that Sarah Boone suffered at the hands of Mr. Torres.
They also knew the abuse that he suffered at
I
her
did the best I could,
hands.
Judge. I filed it.
Really?
I felt like I had to have an expert. I explained in general terms that she was psychologically and physically abused by Mr. Torres repeatedly over a period of time that led to this event.
And he was abused
They
too.
filed their objections, which we believe is misplaced. The court, as you know, by that rule, let me find it.
Am I not correct? Did she not get a domestic violence charge herself?
It's apparent not only that the state was on notice, that we were going to rely on it, it was prepared to respond and was not prejudiced in any way. The notice of intent to rely on the defense of battered spouse syndrome comports with the requirements outlined in 3.201, given the current circumstances of the case. And as you know from that rule, it says the notice shall contain a statement of particulars showing the nature of the defense the defendant expects to prove and the names and addresses of the witnesses by whom the defendant expects to show battered spouse syndrome, insofar as possible. Insofar as possible. I did the best I could, Judge. In addition, As soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good
Will
faith belief
they
that
be
we
able to
had
bring up
corroborated
her
either by witness testimony,
DV
or
charge?
physical evidence, photographs,
Wasn't it
videotapes,
dropped?
medical record, whatever we could find that could corroborate our defense. In addition, we've listed the ex-husband, Brian Boone. And the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses,
Owen?
photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be
James
disclosed as it is
Owens.
discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense.
Exactly.
The original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic. And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law, because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state and wherein our confusion lies is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim.
I was thinking maybe tomorrow, I don't know how to do this, but I'd like to find out his case history, his entire resume.
Her statement to the police is not one of self-defense. It is one of accident. She repeatedly says there was no violence that day. So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related, but it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the
you're
cornerstone
amazing.
of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night,
is the one who died.
So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all of this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement, but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice.
Thank you.
The statement of particulars that is required
You know
by the
how
rule.
expensive these seed beads are.
Where is
How's
it
my
setting forth?
beloved
There's a
doing,
self-defense claim,
darling?
and then there is going to be this shown
By the way,
beyond just the past violence between the two.
I don't want to talk over him. Madam Mary Kay, and those who may not know, guess what I did last night? Does anybody know what a drum circle is? I took my native drum and I went to a native drum circle last night. Mary Kay, we played and you were prayed for, and you were in my heart the whole time. So just wanted to let you know.
Two of them. Thank you.
Judge, they're scheduled to take the
Yes,
deposition.
thank you,
of
Miss
Dr.
Mary
Orr
Kay.
October 1, so they're gonna know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute, but he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge,
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue, from the court's perspective, is it applicable? And that's the hangup that I'm having.
that's not to be decided today. That's not Wagner.
Public
whether
defender
it's an
for only
accident
3
or
years.
Whether it's battered spouse and there was self-defense, that's not to be addressed today or not to be decided today. That's going to be based on the testimony from Ms. Boone about what was going on. But I'd like
Thank
Mr.
you.
Henderson, if you don't, but
that's not what
So-
Wagner stands for. Wagner
His
didn't allow.
behavior is
Wagner
not so
struck
surprising after
multiple
reading that.
amendments. And the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices
Needle
that
poke
were
number
filed in
one.
that case for the battered spouse defense. The
Judge, but
issue,
ultimately, the female defendant in that case claimed that the firearm discharged accidentally. Correct.
So
And the
he's
court-
using
the
his
court ruled,
case-
hey, you can't have it both ways.
I'm looking
It can't
up-
be an accident. And at the same time, be
So
intentional
he's
that you
using
committed as
his case to
self-defense
catapult his
because you're a battered
career.
spouse.
right. So how is battered, even
It's
taking-
premature for them to be arguing the question of intent.
But that's not what Wagner says. What Wagner specifically
specifically?
says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence.
Very
at
well may
trial.
be, my dear.
And the DCA says that the evidence underlying in that case was all accident, specifically the located.
Why are you glitching?
Battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Yeah, I agree with you, Jedi.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions. How is your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was that the overt
But
act
all of
that caused the
but all
death?
of the
Ooh,
battered
that
spouse
judge is
syndrome
getting
cases talk
spicy.
about a defensive issue, not meaning defense your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say
He's not
she
declaring
overtly zipped him up in the
self-defense.
suitcase. I assume they're going to say he was asking to be let out of the suitcase.
That's right.
And she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was direct.
Do you know how you're going to defend this case yet? Because it was either self-defense or an accident. If it's an accident, you cannot use BSS. Am I right? You can't use BSS for an accident. Self-defense, you can use BSS. You should know this. I'm not a freaking lawyer, and I understand it.
directly caused by
Oh, there you go,
Sarah
Carrot
Boone's
Mom.
actions
Thank
or
you.
non-actions.
I didn't see that. Sorry. And I think the judge is going to nail him. This judge has the patience of Job. You can't have
Hickman,
both.
the defendant stabbed the victim to death. And the justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd, 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of
understand that
particulars.
circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped
That's
him
the
up in
problem. You're
suitcase
making an ass out of
against
yourself.
his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge,
Yes!
you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brandon said on the issue of imminent threat, it is in the mind of the battered spouse
But
woman.
right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the
Oh, I
cases.
love this.
I don't know the facts
I
and
love this.
circumstances of
Watch
that West
it.
Palm Beach case. I don't. I know
I'm gonna
snippets
say,
that
whoa,
you
whoa, whoa,
provided
whoa,
to
whoa,
me,
whoa, whoa,
but I
whoa.
haven't read any.
I got to slow this down. I got to get this back to normal because this is freaking brilliant.
Opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that.
But she's got to testify.
That's for her to
Appellant?
testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case.
I tried
holding
to
that
leave
evidence
dive.
of
I
battered
know.
spouse syndrome is admissible where
Getting
the
to my
defendant claims
favorite part of this.
accident rather than self-defense.
Who claims accident? Who claims?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Never came out of your
Words
mouth.
That you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the
That's
record,
right.
We're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay.
How in the hell is zipping a man
Not accident.
in a case
as they want
self-defense?
to allege.
Okay.
Okay. Once again, if I get this wrong, somebody nail my butt. I give you permission. But you can't claim self-defense if something happened 2-3 days ago, a week ago. Oh, I did not. If you want to drop that in my Discord DM, I will play it. I've heard about it, but we haven't watched it. If I'm in a relationship and we get in a fight 3 days ago and he beats the living tar out of me, then the third day later, today, I decide that we're going to get drunk and I'm going to put him in a suitcase. I'm going to zip him up and I'm going to punish him and I'm going to leave him there. And he dies. That is not self-defense. That's manipulated, calculated, thought out, flat out, second degree. If today I'm beaten to a bloody pulp and he comes back in the room and I have my weapon and he's got a crowbar and he's coming at me again and I'm in fear for my life, I discharge that weapon. There's your battered spouse. So, lawyer, I think you just convinced me to go to law school because if you can do this, I sure in the hell can.
Does your compatriot want to provide response further? Okay. Mr. Henderson, good afternoon, sir. Can you hear us? If you can hear me, sir, you need to unmute yourself.
Can you hear me now, Jed?
I can, but I have some concerns because I'm getting reverb from you.
Sir, you're going to need to put headphones in.
Are you able to hear me better?
I am, but it's my that we're hearing back again through your microphone.
You need to get hearing earbuds.
Turn that button then.
I hate
This
Zoom
may
for
work.
court. I think Zoom for court is ridiculous. I don't understand what they would have done if they didn't have this. And I wish y'all could see my feet is flickering like crazy.
Mr.
My
Henderson, we'll
monitor's
give this a shot.
my
sir.
monitor's brand new and
You can
it's
go ahead.
flickering.
Yes, sir. Can you hear me now?
I can, sir.
Oh my
Is that better?
God.
Yes, sir, it is.
Yes.
Hearing
Yes,
aids
Judge,
make it
I'd
worse.
like to respond. And first, where I want to start is here. But just the
I can't understand him
justifiable use of
at all.
deadly force, justifiable use of non-deadly force. Those are defenses that do not require a notice at all. A defendant doesn't have to come in before trial and say that I am relying
Nope.
on
Cat mom.
self-defense.
I mean karate cat mom. No.
The standard is just it's in the
I have
standard jury
2
instructions and
older
before that.
monitors that are flickering. I may have to replace the cord. Chris, turn it down. You want me to turn it down?
An indication or evidence is just in scintilla of evidence, is what cases say, to get the instruction.
Is that better?
There's no notice requirement in self-defense at all. Now,
No way.
Rice syndrome is not a defense in and of itself. There's no such thing as a defense there. It is a part of a jury instruction, and the part of the jury instruction and what it explains is when you
There went the compressor. I could feel the difference in my ears.
danger, and that because of this syndrome, they would perceive an imminent danger different than someone else. Because what the self-defense instruction
You'll be Girl Friday, Ada? What does that mean? I know what Girl Friday is, but what do you mean?
in those circumstances,
I miss you, Ronnie. I feel a little distant.
those circumstances. So the first instruction that you have to get before you can even start talking about that spouse is this. You have to get the self-defense instruction. So, and that would be decided based on the evidence at trial. The defendant doesn't have to come in and say, I am claiming self-defense. This is self-defense. There's no rule or circumstance to that extent. But there has to be testimony of self-defense. Now, once there's testimony of the self-defense part of it, then the court can give that instruction. If they find it sufficient, the testimony can give that instruction as to self-defense. Where that spouse comes in and it goes into a series, you have to have self-defense or some type of evidence of abuse before you can get into the battered spouse. And this is how it should work. There could be the testimony of Ms. Boone. There could be testimony.
Who is this guy?
Actually, in the notice from officers who responded to
He doesn't know it's that bad.
physical injuries on Ms. Boone.
No,
Testimony
we didn't have any rain that I know of, but I was out of town all day.
who observed injuries or certain things to Ms. Boone.
I think this may be the I'll replace the cords first. As long as it's not affecting y'all, we're good. And you look this way when you are speaking. Deaf girl wants to try and lip read. He's reading it off of a dry erase board. Congratulations.
Once the expert's testimony becomes relevant, then the expert can testify about these are the symptoms that I observed, this is what I watched.
Oh, yes. You can be my girl Friday. May need to hire one if I get good at this.
So after that point, Judge, when you get to that point, then
If I become another Emily D. Baker.
at that point in time, it becomes a jury question. And it's up to the jury to decide. And what it does, and it doesn't say that
I won't, but I can dream.
what it will talk about in the jury instruction is this is something an abandoned woman would under these circumstances, if you find it credible, that you can consider. And that's what it does. So we have had at the beginning when we started talking about motions to strike, because if I take the case with Wagner, there wasn't any testimony there. Wagner's testimony was accident, and that's it. And I really put no one reviewed
Can we skip him? Are y'all okay if I zoom forward?
we do not have testimony. What we have is a say in this case saying the discovery in this case Joe did it.
I'm gonna zoom.
But that's not so. These women practically know better. And that's all I have, Judge. Thank you.
Ah! Ah!
Mr. J, any response?
Whew.
It sounds like we're largely on the same page.
Mute the dude.
The one point that I would strongly disagree with is that this evidence of battered spouse syndrome is relevant to the subjective belief of the victim or the defendant. That is not what evidence is used for. It's used to help a jury understand what an objectively reasonable person would do in those circumstances. And there's more cases that I have not cited because I didn't know that would be raised today, but they kicked out PTSD testimony just last year. I believe it's an Okendo because it was going to the subjective beliefs of the defendant rather than helping the jury understand why an objectively reasonable person in a battered spouse syndrome would stay. But that notwithstanding, it appears we're on the same page that the jury should not be hearing anything about battered spouse until the predicates are laid. And from the state's position to help us prepare for trial, pleading should be sufficient. And it's still our position that the pleading was insufficient. The state is well aware of the past violence between the two of them, with her being the aggressor and the decedent being the aggressor. There's evidence of that all throughout the discovery. But what isn't present anywhere in the discovery and what left the state at a lapse in understanding this defense in particular was, did this violence cause her to suffer from battered spouse syndrome? And what is this evidence going to be? Was he isolating her? Was he keeping her away from family and friends? Was he psychologically breaking her down? Was he doing any of these things that are a component of the battered spouse syndrome? Because all we have is her statements, which are almost 100 pages long, to the sheriff's office, where she repeatedly says that night that nobody laid hands on one another. It was a great night. We were hanging out.
Fact, it's been almost over a few weeks.
Painting, dancing with the dog. And then, like everybody else, we were playing hide and seek. And he got into the suitcase, and I accidentally went to sleep. And then she's shown her video. But her statements are all that it's an accident and that there was never any claim of violence that day between the two of them. So that's wherein the state's confusion lies. And I don't know how we're going to go about this at trial, if the defendant's going to have to testify in a narrative form, if she's going to come in and testify 100% differently.
Oh God, not
another
one.
But
No.
that's where we're at, is we don't want this
No
in
more
front of the
narrative.
jury until
Please.
all of the requirements are met. And as far as I know, the only person that can say that it was a justifiable use of force that night is her, because it was only her and the decedent in the home that night. And thus far, she has not made any statements about a justifiable use of force. And then
That night.
our second complaint about the intent to rely on the syndrome, again, without repeating myself, is it just sets forth that there was past violence between the two of them, but no particulars about what actually makes up the rest of the syndrome. Thank you.
Any other final positions offered in rebuttal to the state's argument, either Mr. Owens or Mr. Henderson?
Well, I'll let Mr. Henderson go, but just as it relates to Ms. Boone's testimony, that's what jury trials are for.
Mr. Henderson, any further arguments, sir? You're muted. You will have to unmute yourself.
He's not even in
Mr.
the
Henderson, you're
room.
still muted, sir.
He does not know how to do this. Dude,
I'm sorry.
get him some
Can you
help.
hear me now?
Loud and clear, sir. Any other additional argument in rebuttal?
Yes, Judge. The state is going to have the opportunity to depose the expert, Ms. Harper. Tie those things together. That's why we have experts who know about these things and who have the knowledge, who can tie these things together and tell why she's of the opinion that she was suffering from bad spouse at that time. The notice is simply to require to let them know that we're seeking this avenue and here are the witnesses that we're using to seek the avenue. We don't have to list a specific number of witnesses. It's just the ones that we intend to use. And as Ms. Owens has told you, this is an ongoing process and we'll probably be adding more. But that's all I have. Thank you.
All right. Thank you very much. The court is going to take the issue under advisement and provide a written order. I'll endeavor to do that by the end of the week.
Did we get that written order?
Last is the
we
defendant's
get the
motion
written
for
order?
enlargement of time.
Anybody?
filed September 17th.
Anybody? We should
Um,
have it.
Mr. J, have you had the opportunity to review that?
Yes, Your Honor.
Okay, all right. Any problems with proceeding with that this afternoon?
No, Your Honor.
Okay, very good. All right, I have reviewed that motion. Mr. Owens, you may proceed, sir.
Judge, and I do have about 2 or 3 other issues that we need to address, but I've asked for some time. I think there was an order. I know there was an order that you had submitted to writing and that was filed with the clerk's file that indicated that
That you were screwed.
you wanted some things from the defense and from the state by certain dates. And I think that's a typo in paragraph 3. I said August 17. That should be September 17. On paragraph 3, Judge, of my defendant's motion for enlargement of time.
It says September 5 on paragraph 3.
Are you looking at my defendant's motion for enlargement of time?
Yes, sir. Paragraph 3 says Dr. Julie Harper met with defendant Sarah Boone on Thursday, September 5, 2024. Am I looking at the wrong
Okay.
thing?
I'm sorry. I was looking at the wrong one. If you look at the second page,
Yes, sir.
paragraph 7,
Yes.
that should be September 17.
Yeah, got it.
Okay.
I mean, obviously, the court's order, the August 5 order speaks for itself.
Judge, and as you know, we came in late.
Oh,
Dr. Harper formed
man!
an opinion that week. We
God,
filed
if
a
I
notice
hear
of
that,
intent to rely on battered spouse.
You know what?
It's ongoing.
I need somebody to help me get this ATM mini extreme hooked up. Because then I could put a counter up and we could have counted how many times he has said, Your Honor, we came into this late. Falling asleep, Ada, is more hardcore than Cat. Oh, jeez. Well, if you need to go to sleep, go to
That's all I
sleep.
can say. We're working.
We'll miss
we're doing
ya.
everything we can to uncover evidence consistent with our defense. The problem is it's 4.5 years ago, and the apartment
Where?
complex in Winter Park has changed hands. So we're trying to run down the employees. We're trying to run down the other.
That's your
tenants in
problem.
place. We're trying to run down medical records. That office manager is critical. We've taken her deposition, but we can't find her. Brandon, I think it's Moats, the neighbor that lived right next door to Miss Boone and Mr. Torres, and they shared a wall, is a critical
Damn it.
witness in the case. We're trying to locate him. As you know, 4.5 years, people move. So
Sounds like a personal
more time.
problem to me.
is my point. We're doing everything we can. We're working diligently. Billy Lane, the investigator, is working diligently to try to gather the information I'm asking him to gather. Coupled with the fact that we've got this phone that we're going to be extracting, I'm in hopes of in a few days. And I know that the state had extracted the phone and given us a lot of the data from the phone, but Ms. Boone says it's incomplete. That's the reason we want our own expert to extract it. that will be able to assist us
And
in
Boone
establishing evidence
doesn't
and
kn-
testimony that she is a battered spouse and was a
Miss Boone doesn't know whether or not if she is winding her ass or scratching her watch, as Dolly Parton says.
battered spouse prior to this event. But because of that, Judge, we haven't had time to complete that. And as I said in my motion for enlargement of time, we're asking
Hey,
to be
Jedi Jess,
flexible
question. Can he,
on some time limits.
okay,
Up to and
can
during the week
he,
of the trial. Because we're going to be working that entire trial. Like I said, there's 18 days
decide to
until
drop this
trial
case?
starts. It's going to be a 2-week trial. I don't know when some of this information is going to come, but I assume every other day we'll probably be amending the discovery, the reciprocal discovery, and amending the notice of intent to rely on insanity or rely on battered spouse if we find other evidence that corroborates that. So we're just asking the court, and I know there's a rule that specifically
Where did
this
she
rule
put it?
3.050
I can't find
that
it.
allows for this request. Thank you.
Lay
Thank you very
down.
much. State, any response?
Certainly, the state is not going to be okay with them conducting.
Ronnie,
their
I don't know where she
investigation
put
if
it.
Jeopardy has been attached. That is completely unfair to the state.
I'm
This is
listening.
the
I got to do the
defendant's
doggy
trial,
do.
Not Mr. Owen's trial. She has
Ronnie,
been on
if you can
notice
get
of
it,
these
I
charges since February
went
25th
through everything I had
2020.
earlier in this
She has gone through
live.
countless
I'll be
attorneys
right back.
here
Time for
who
doggy
did
do.
not pursue this battered spouse syndrome defense, even though they had consulted with Dr. Harper back in 2020. And I believe the crux of that issue is going to revolve around her having to testify in the form of a narrative given her prior statements. So the state opposes any enlargement in time. The defendant has been on notice and has had centuries probably of legal expertise at her disposal for the last 4 years. And there may come a point in time where the state has to request a continuance prior to trial, but if this enlargement is granted. But certainly, once Jeopardy has attached, that's not the time to be doing discovery. She's had 4 years to do this, 4.5. Thank you.
Any other final arguments, Mr. Owens?
No, sir.
Okay. I'm just rereading the rule. Give me a moment. Mr. Owens, as I stated when we had our hearing on September 3rd, at that point in time, the court had outlined the history of the case, the court's prior findings, the numerous experts that had been retained throughout this case, and I understand the position that you find yourselves in. But at the same token, based on the same analysis that the court had relied upon in its oral pronouncement in denying your continuance on September the 3rd, I'm going to grant your motion and deny your motion in part. With regard to the filing of objections to the state's exhibits, by your own statement, you're still in the process of going through those. The
Okay, I
deadline
did get,
expired on
no,
September
these are,
17th.
yeah, I got them.
So I believe
Ronnie,
that we're
got
using
them.
the second portion of the rule with regard to that issue.
Got them,
because
got them,
there is a
Ronnie. We already
requirement
discussed
to
them.
provide those
Thank you.
names, and this motion was filed on the 17th. So I'm going to grant your motion in part with regard to filing objections for the state's exhibits. I will give you up until the time that we're having our trial case management on September 26th to file any additional objections to any of the state's exhibits. With regard, however, to the filing of a witness and exhibit list, I agree with the state. We can't be amending once Jeopardy attaches to provide additional experts or any witnesses at that point in time.
You're talking about Jeopardy when the jury is sworn
Correct.
on that Monday, October 7th?
If we're lucky enough to get one on Monday.
So
Just so that you understand, I've ordered a couple hundred people for that week because I don't know how long jury selection is going to take. I don't know what people know about this case.
Judge,
So my intention is to run 50 people in the morning. So I'm just letting y'all full disclosure here, what my thoughts are. 50 people in the morning, get rid of language, get rid of cause. And if those persons who don't know anything about this case, I'm going to ask them to come back either Tuesday or Wednesday. And then we're going to run another 50 at 1:30. Get rid of our cause challenges, those who can't be here for 2 weeks, those who've just recently given birth, all the statutory cause reasons that they can't be here. I'm going to ask them to come back. And if we've got 40 people, 50 people at the end of Monday, we'll start Tuesday and we'll start whittling it down. And I can turn over when I'm done with my colloquy, my voir dire is about an hour and a half, 2 hours. And then I'll turn it over to the state and I'll turn it over to you and we can whittle it down from there. But if it takes us more time to get a sufficient panel because of the amount of time and other causes or preconceived notions about this case that can't be set aside, we may not be picking a final jury until Wednesday in this case.
It's just
Shoot.
set for 2 or 3 weeks.
2 weeks. 2 weeks. Now, it was originally set for 3 weeks. And then when we talked about it, when you came on board, we had shrunk that to 2. Now, if we think that that may change, I'd rather discuss that now than a week from now. If you think we need 3 weeks, I can try my best to make that happen. But I respectfully need to know that sooner rather than later.
Good for you, Your Honor.
Because in all candor, I don't know how long it's going to take us
I
to get a jury.
did not anticipate, I anticipated we were going to be able to pick a jury in one day.
I would love to be that bullish. I hope we can. I'd love to be able to. I'm just
Possible.
telling you what I've been working with jury services, that I've got 50 people teed up for 9 a.m. I got 50 people teed up for 1:30. And that will continue throughout the day, the week. It's easier for me to say, we don't need you, go home. You don't need to show up for jury service, than it is, I need bodies and we don't have them.
That's
Now, if
true.
we're able to get a jury in one day, fabulous.
I really like him.
But if we can't, I have that backup.
I believe if we pick the jury in one day, we could try the case in 2 weeks. But if it's going to take a little bit longer, and again, we don't know from now until October 7th what other evidence or what other witnesses we're going to uncover. So in the abundance of caution, I'm going to ask the court, if possible, to set 3 weeks. I don't think it's going to take 3 weeks, but I don't know how long jury selection is going to be. I don't know what additional evidence we're going to uncover, additional witnesses from now until October 7th. So to be on the safe side, I would ask for 3.
Okay. All right. I'll see what I can do there and I'll have Anita report back to both of you.
Judge, and the main reason, I think all these other lawyers, they didn't have an expert that had tendered that opinion about her spouse. So we started on this path on that Friday when Dr. Harper called me and I filed the notice of intent to seek corroborative evidence, corroborative witnesses that she was battered. So that didn't really start until that day, which was September 6th. And
When?
that's why, and again, this was an event that occurred 4.5 years ago. Trying to locate witnesses is just taking time. I understand about the jury being sworn and we shouldn't be allowed to ask additional witnesses to come in. So I agree with the state on that. I agree with the court. But I would ask up until the time we pick the jury that we be allowed to amend reciprocal discovery and amend our notice of intent to add additional witnesses and additional evidence.
Mr. J, any other further position, sir?
There just may come a point in time, Judge, if you don't set a deadline, that the state has to ask for continuance.
The deadline is going to be for objections to the state's evidence, providing of a witness and exhibit list for the defense at trial case management next week, September 26th at 9 a.m., in addition to all the reasons that the court placed on the record on September 3rd during the motion to continue. My JA has advised that Mr. Lake has appeared virtually with regard to the motion to appoint clinical psychologist. Mr. Lake, can you hear me?
Yes, I can, Your Honor.
Can I get your appearance for the record, please?
Yes, Christian Lake on behalf of the Justice Administrative Commission.
All right, thank you, sir. Earlier today, before your participation, I know that Mr. Owens had provided you certain cost motions regarding the forensic psychologist, Dr. Harper, and the crime scene investigator, Dr. Birkeland. You had advised as the JACS's positions on those motions.
We don't
Your
have
email
one.
has been filed in the court file. Subsequent to that, a motion to appoint clinical psychologist regarding Dr. Michael Brannon was filed. That was just filed yesterday. I know my judicial assistant sent you a copy of it. Have you had the opportunity to review that motion? And if so, what is JACS's position?
Your Honor, just briefly, we did review the motion. Although we're not contesting it beyond objecting, we do object to any rate in excess of the rates established by law, but we acknowledge for this type of expert, it would not be uncommon to approve a rate of $200 an hour. It's if that does exceed the rates established for this circuit.
Mr. Lake, I hate to interrupt you, sir. Madam Court Reporter's having a difficult time hearing you. If you could start over and slow down just a smidge for us, we would greatly appreciate it.
Not a problem, Your Honor. We did review the motion to appoint the expert. Just to give the court some background, because I went back and looked through our files. So far, the defense has incurred, this is prior to Mr. Owens' involvement, but so far the defense had previously incurred $7,500 for one mental health expert, and that's the same mental health expert as being, not this expert, but was the other expert being requested, was requested by the defense in the other two motions. The defense also incurred $1,800 for a mental health expert that was hired by Ms. Cashman. That was, let me just get the right name, I don't want to say the wrong name, but she was paid $1,800. She was retained in relation to the issue that was before the court today, the battered spouse syndrome. And now the defense is requesting a third mental health, but also at the rate of $200 an hour. Based on the nature of the case, Your Honor, we have no real, other than objecting to the rate because it does exceed for the circuit. We don't have any other concerns about the appointment of the expert. It would be the third mental health expert appointed to assist the defense. But that really, I mean, ultimately that's your call whether to allow the defense to incur costs for a third mental health expert.
The motion reflects the rate as $200 per hour. Is that in excess of the JACS rate?
Your Honor, in excess of the rates for the circuit, those were the rates that were adopted back by the old Indigent Services Committee back in 2007. We essentially generally don't ask for a hearing unless the rate is over $200 an hour. So we generally, again, we acknowledge that is, the rates generally range for mental health experts range between $150 to $200 an hour. So we don't particularly object to them. As far as what the rates were at that time, they are posted on our website, and I'm pulling them up right now because for the Ninth Circuit, the rates for medical doctors and psychologists are $160 an hour for out-of-court services and $178 an hour for in-court services.
State anything further. Okay, all right. The court is going to grant the motion to appoint Dr. Brannon. I know that the state advised that this is not going to be nunc-pro-tunc because I've received nothing from you, Mr. Owens, that he's done any work yet.
That's correct.
Taxpayers
this will
are
be
paying
effective
for
as of
100%
today,
of this.
the 17th of February.
And there's a lot of money that's been spent on experts
September.
that they're not going to use in
Yeah, is that
trial.
what I just said? I'm sorry if I did. Said
Thousands, as you just heard.
I will take it under advisement the issues pertaining to the battered spouse syndrome and provide a written order. You had advised there were some other issues that you wanted to bring up, sir.
Do we know if the judge did file his amended response? He was supposed to file it within the week. He did not.
That's to the investigator, Billy Lane, who's working with the defense and his potential costs.
Wait a minute.
Up to the trial.
Are these being hand filed now?
Mr. Lane handed them to me right before we came in, so I'm going to have to scan these in and file them.
Okay.
I wanted the court to be aware. If you want to address it at the September 26th case management conference, we can do it then.
Let's do that. Just do me a favor if you could, sir. Once they're filed, just forward them to Ms. Barrios.
Okay.
So that I've got hard copies of them.
All right, I'll
I'll
that.
give these back to you, sir.
Judge, the other thing was, of course, we've got trial coming up quickly, and generally, when in a courtroom, I do opening statement, maybe have some demonstrative aids, but I'll walk around, and I understand here that we've got to be in front of a microphone. Is there any way we can set up, maybe the defense can set up a system where we can wear a mic so that we can walk to some degree?
I will have to check with court admin.
All right. And then the other thing is, we would like Sarah to wear street clothes.
Oh God, here we go into this.
So do I
This
need to
pissed me off.
something?
I have, get in touch with the public defender's office. When Miss Boone was
Just
representing
wait.
herself, I had coordinated and communicated with the public defender's office multiple times in an attempt to obtain clothing. Before you came on board, Mr. Owens, Barry Click, BARRIECLICK, had provided the total amount of clothing that they had that would fit Miss Boone, including shirts, pants, slacks, skirts. And that was the time where she would be allowed free reign and was going to have the shock device on her lower leg. I would ask that you can email Miss Click. You can find her information on the Florida Bar webpage, and ask her if the public defender would assist you in providing clothing. They were going to while Miss Boone was representing herself, and I imagine that offer would still be extended.
Judge, and I anticipate 2 more pretrial hearings. One is the case management conference, and 2, if I file the motion to suppress the statement made during the interrogation, we would probably have to set a separate date. Can she wear street clothes at those 2 hearings?
If you could get it to her. So that's something you have to work with corrections. I don't know that they're going to let you do that.
Now, when it comes time to trial, we would like, she would like for us to have some makeup for her and somebody to fix her hair in a way.
Fix her hair. Look at the haircut. She just cut my chair's woggling weird. Her hair's been cut again. There is no hair to fix. What does she want? A weave? She's cut it all off. I'm all like, what the hell? I'm not sorry. My dear. Miss Boone, are you listening? Oh, right. You don't have a computer no more. Baby doll, you are not Martha Stewart. You don't have millions in the bank to pay for someone to come and do your hair. You are indigent. You are freaking delusional. Hell. But she wants us or them in her state as taxpayers to pay for it.
Way that's presentable to the jury that she would like to be presented. Do I need to file a motion on that, or?
I think you're going to have to.
And he's
I'll
going to
bring this
look at
on.
him.
Okay. All right.
I think he's
Anything
like,
else, State? We
are
need to
you
discuss?
shitting me?
All right. Anything else, Mr. Owens, or from your co-counsel?
No, Judge.
Okay. I will see you all on September 26th at 9:00 in the morning, and I will endeavor to get you a ruling on the battered spouse issue as soon as practical, hopefully by tomorrow.
Thank you, Judge.
All right. Thank you all very much. We're off the record.
Trial TV Live, Ada K frequently makes announcements for your channel as the gavel drops. I do. So, speaking of, I was just getting ready to say that if you like to watch coverage without commentary, or you want to go back and watch something without commentary later, go to Trial TV Live. They are partners. Rather, they didn't ask. I'm telling them they're my partner. If you don't want to be, speak now, forever hold your peace. And then we get a lot of documents from As the Gavel Drops in Discord. It is a fabulous place to go to be able to read for yourself these documents and and research and dive into cases. Right now, they're covering approximately 500 different cases. We love you too. We do. Oh my gosh. No. Uh, I'm I'm all like, honey boo boo, there's no fixing messed up. You're so all kinds of messed up. You can throw up all the makeup and hair, fake eyelashes, get your nails done, wear all this fine clothes. Yeah, because honey boo boo, you're going away for life and you will never experience that again. I, I I bet when he's sitting at home talking to his wife over dinner, they have one hell of a good laugh. Yes, mommy was laughing. I'm good. I'm okay. You can put lipstick on a pig, still looks like a pig. Spa day for my cat, lay about 2 hair. I'm Why should we pay for all that? If she can get somebody to provide clothes, they can buy her makeup. Go to Walgreens, or even better, go to the dollar store where that foundation is full of old bacteria. It's starting to separate. You got to shake it real good and mix it to make it work for you. And then the eyeshadow, ooh, yeah, chalk. Let's put that on her. And not to mention the lip gloss and the lipstick that's old. Ugh. Y'all don't buy makeup. I don't care what brand it is. Don't buy makeup from the Dollar Tree. Y'all, look at the expiration date. Oh, lordy. I I I I have very good makeup. It's professional because I'm a professional makeup artist. But anyway, you can pay me. I'll gladly go do her makeup. $1,000 a day. And fly me out there. Put me in a hotel room. Maybe you ought to call and volunteer. Fly me out there. Put me in a hotel room. Pay all my expenses at $100 a day. And then I get to sit in court and report back to y'all. And Mary Kay, only you would know what Bondo is. One of the things I did in my early 20s, I was a Bondo girl. I would sit there and Bondo cars. After they drill the holes in them to pull them out, they had that thing with the screw on one end and a shaft of metal, and then they had a weighted handle, and they bang it to pull out the car. They get it all done. Then I sanded it, I bondoed it and get it looking like brand new before they painted it. Spackling and Bondo ain't gonna help this girl. It's one thing if they can ask, if they can have their friend, family, or the lawyers provide some makeup, maybe a curling iron, and she can do her hair and makeup. That's one thing. But honey boo boo, if this judge allows the tax dollars money to pay for hairstylists every freaking day for 2 weeks, this girl is gonna go bad crazy. Y'all, this is almost making me go red. Oh, honey, it's not that it doesn't stink. She doesn't have any. She don't have any. By the way, this is what I say about Miss Sarah Boone. I can't stand this. This is just a tad too far. Hey, Karen, way too far. It's bad enough She's wasted thousands. And thank you again, Mary Kay. Thank you, thank you, thank you. She has wasted thousands. Probably when I went through the financial list, and I did, only the small one that was provided, it was almost $60,000. I'll go through it again. I wouldn't even take the trash out for Sarah Boone. Yep. So she sat there, and now they're wanting thousands and thousands and thousands more. It adds up. You're right, Pickles Knit. Adds up so fast. And I'm all like, holy crap. Y'all. Okay, I have a serious question. Are y'all okay with me switching our Saturday night tea to Sunday night tea? Because I have homework assignments due on Saturday, and right now I'm getting them done early, but I've got finals, midterms, and all that that I have to think about. And also, um, I'm missing a lot of family events. Like next week, I have powwow. No, I'm not going to put full regalia. I won't wear the dress. I'll wear everything else with a ribbon skirt. Okay, so we're going to move it to Sundays. Y'all. Oh, drop your link. Drop your link, Kristen. Just drop the link. Yep. Yep. Okay, we're going to do that. And I get to tell y'all about powwow. Maybe show you some videos and pictures next week. Kristen, hurry, drop it. Um, so really, right now, I think this attorney is in over his head. I think this is definitely well over his head. I don't think he realized he bit off more than he can chew. And the fact that he shut down his entire practice pro bono. How can you afford this? Are you thinking that this is going to elevate your business and bring in more client? Let me educate you for a minute as someone who's been a client. If I had the opportunity to watch my attorney, which I did in court before hiring him, if you were that attorney, I would not hire you. I would not hire you at all. Congratulations, Karen. Oh my gosh. She's running late. She'll go live in 45 minutes. Okay. This guy, if he thinks this is going to help catapult his law practice, the way he's running this trial so far, I think not. I don't think this is going to help him in his practice at all. I don't. And I'm not saying to be mean, not saying to be mean, but it definitely. Oh, I love your thumbnail, by the way. I love your thumbnail. I cannot imagine this helping him. Let me see. Where'd you post it? Where'd you post it in Discord, babe? I don't see anything new. Was it that baby we saw the other day? That precious little thing. I don't see Toxic Orchid tonight. I think she's probably resting. Her and that little new baby. Did you put it in member chat? Oh, by the way, we had, and I I gotta find the video. I don't know where it is. 6 or so firefighters in a fire truck involved in one car, that truck itself rolling over. And oh, okay, that precious thing, it was gorgeous. Um, and a lot of them are very serious condition. Their vehicle flipped. I don't know why. We also had 20 people shot and at least 4 deceased in Massachusetts today. Our prayers go out to those families. Um, it has been a very hard month for um, mass shootings. Does anyone have bail money and I will get me out? The guy that lives right behind me has every night ritual of building a shed. He will be done around sunup. Kristen, does your community have a sound ordinance? Or even if not, you can call 911 and say, there's a guy at midnight, 1, 2, 3, 4, building a shed and it's keeping everybody awake. Will you please go and tell him to stop it? Just stop it. Oh, Lord. Oh, Karen, look at that beautiful baby and the hair. Gorgeous. Oh, I don't have a grandbaby yet. No, that was in Birmingham that happened, not Massachusetts. But the mass shooting, oh, I said mass. It says 21 people shot, at least 4 dead en masse. Then it says very tiny shooting in Birmingham, Alabama. We're praying for you, Birmingham. It's horrible. We it grieves me. It grieves me. All this stuff going on. It's horrible. Absolutely horrible. Beautiful baby. Beautiful, beautiful. Okay, guys. Well, I am going to figure out what to do tomorrow because Court TV, if you're still on, do we have anything happening tomorrow? Does anybody know? I didn't see anything tomorrow. So I may come on a little later tomorrow. Ooh, excuse me. I'm yawning. Here it is. 8 California firefighters rush to hospital after fire truck flips on freeway. Y'all want to see how bad this is? Oh, y'all, I really feel bad. I really do. It'll probably show a commercial. That's okay. Nothing I can do about it. Let me turn the sound on. I don't know why the sound's off. Why is the sound off? Can y'all hear it? Do y'all hear it? I can't hear, but look at that truck. That is, I heard that. Might come on after this. I don't have any sound. But anyway, that is what happens when a fire truck explodes. And yeah, that is horrific. The truck body is on the side, a cab. The body is totally upside down. See, that's totally upside down. This, if you see from the backside, this is totally separated from the cab. It's off of the base of the axle and the frame. It is. They didn't just flip once. That thing rolled. It was bad. And so keep those families in prayer. Um, it's horrible. Okay, guys. I'm going to, is there karaokeing in 30 minutes? Okay. I will try. I'm not going to come on and sing. I'm not in singing voice. But I'm going to listen on my drive home, and then I'll go home and I'll have you on my phone. Is that okay? Ronnie, no, he's unemployed. Just consider piece of what? What are you talking about? Oh. You guys, I wish you could see my dog. Nothing tomorrow, but Boone is Tuesday for one of her motions. And Thursday, the 26th. Yep. Okay. I may take tomorrow and get all my homework done and just do it in one day. And then the rest of the week we're on. We'll see. Y'all, you got to see this. Come here. Over here. Sensei. Up, up. Sensei. Up, up. Come on. What? You want to go home? You want to go home? Is that what you're telling me? You telling me it's time to go home? Huh? Who's your good girl? Who's your good girl? Say hi. Hi, son, my baby. Oh, all right, down. I hate doing that. You can also see how fat I am. Did I text you? When? No. I don't think I texted you. If I did, I don't know it. Okay, guys. This lark butt is going to head home. I've been on the road and gone all day. I don't remember, babe. If you texted me and I texted you back, maybe. I don't know. I have no idea. I've slept since then. I will see y'all sometime tomorrow. Who knows what's going to pop up? I thought about doing an Adelson watch where we watch the Adelson, Charlie Adelson's testimony. I have not seen any of it myself, so I have been watching his case, trying to get a good grasp of it because his mama's going to trial. And I want to be caught up to date for that. I don't want to be behind the wheel for that one. Maybe we can dive into that one because after her trial's been delayed, but she would be after Boone, I believe. Not sure. Okay, guys. Everybody, thank you for joining me tonight. It was a pleasure having you in my humble abode. I will do my homework tomorrow morning before I go live. Everybody, thank you so much again. Please, if you haven't subscribed and like, it is the best way you can help me right now. We are now 5 months old. We have hit over 2,000. We are doing good considering how new we are, but I want to keep that growth going. And so it doesn't cost you anything. So I would appreciate if you do that. In the meantime, thanks for chatting and us diving into Miss Boone. And we will be doing more on Tuesday about her. Once again, be kind to somebody who needs it. You may be the only one that shows them love that day. All right. Good night.